Delivery for order, negative number 1.
For reasons mentioned in the order, the petitioner is allowed to go on bail of rupees 1 lakh with two sureties of like amount, subject to certain conditions.
Make please a lot. That I beg to mention item number 49, my lord. It is an order item, but I want to file an affidavit in opposition, my lord, against the application, my lord. So some time may be granted, my lord.
You are for
I am for the now respondent. Yeah. Opposite
Other-
party.
others-
I have taken the consent of the other side, my lord.
Okay, heard Mr. P.K. Kalita, learned counsel for the respondent side, who submits that he intends, the respondent
Secondary.
shall file the affidavit in opposition. Affidavit in reply. Affidavit in opposition.
Opposition.
In the, you will file an objection actually.
No, my lord. Actually, the second appeal was dismissed for default for not taking steps, my lord. They have taken certain grounds. I have to.
So
reply,
you
my
are
lord.
filing written objection against.
Yes.
A written objection against the interlocutory application filed by the applicant side. He has submitted that he has informed the learned counsel for the appellant regarding his making the prayer is allowed. Let this matter be listed after
In the first week or second week of November, my lord.
in the first week of November. In the meanwhile, the respondent may file the written objection as desired by him.
May please, your lordship. I'd like to mention item number 16 of today's daily.
16.
16, your lordship. The dispute is between brothers. Some deliberation is going on, your lordship, to settle the matter. So may be taken up after vacation, your lordship, ensuing puja vacation.
Heard Mr. H. Bura Gohai, learned counsel for the appellant, who submits that there is a possibility of amicable settlement between the parties, and therefore he prays for some time for the same. The prayer is allowed. Let this matter be listed in the first week of November.
Deeply obliged.
May I please answer? I beg to mention item 57, my lord. We have taken consent, my lord, from the other side, my lord. He is present, my lord. May be taken up next week, my lord.
My lord, this is a whole pending matter. Your lordship.
Next
Yeah,
week.
2016 matter. So matter may be fixed that your lordship on 3rd October, your lordship, on
3rd October.
Thursday, your lordship.
It is a hearing matter.
My lord, 2016 matter, your lordship.
No, but 3rd October, we have fixed matters. Already we have fixed matters.
Then you will say first, you will say Tuesday, you will say. All pending matter, 2016 matter, you will say. Several occasions it has come, but not listed and not.
22nd October. 22nd October.
Must.
On request of learned counsel for both the sides, let this matter be listed again on 22nd October for hearing.
Obliged, my lord.
Must.
May I please, your lordship, with the consent of other side, lordship, I beg to mention item number 32, 37, 38 with 39 and lordship 46, lordship. My senior has some personal difficulty, lordship. That is, I am praying for.
32, then
37, 38 with 39 and 46, lordship. It may come after vacation. I am for the appellant.
you have taken consent of the other side.
Lordship, I have taken the consent.
May I please, your lordship? Matter may be fixed at a date after vacation.
This is for orders.
All matters are orders.
Orders,
37.
no date. Heard, Mr. What is your name?
A.R. Das on behalf of Mr. R.C. Paul. my senior.
A.R. Das, submitting on behalf of Mr. R.C. Paul, who prays for an adjournment due to personal difficulty of the conducting counsel. Also admits, what is your name?
Shabnam Ahmed. I am appearing on behalf of KU Ahmed.
Shabnam
Ahmed.
S. Ahmed, London. Appearing on behalf of
KU Ahmed.
KU Ahmed.
Item number 37.
This is in item number 37. 37 learned counsel for the respondent slash caveator. Who does not have any objection regarding prayer for adjournment made by the council. Let this matter be listed after puja vacation on a date to be fixed by registry.
Much obliged.
May I please, Lordship, I beg to mention item number 8. Lordship, my senior Mr. D. Kalita is unwell. Kindly adjourn the matter for today and the date may be fixed after puja vacation.
Heard Miss
R. Kaur.
R.
Kaur.
R. Kaur, learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting counsel, Mr. D. Kalita, is not well. Stop considering the ground mentioned by the learned counsel, the prayer is allowed. Let this matter be listed after puja vacation.
Right.
May please, sir. I have to beg to mention item number 51 also. Kindly matter may be fixed after puja vacation. My senior some personal difficulty.
Heard Mr.
As new.
S. Neog,
Yes, sir.
learned counsel for the applicant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Stop. The prayer is allowed. Let this matter be listed after puja vacation.
Much obliged.
Lordship, I beg to mention item number 9. Lordship, we want to get some instruction from our client, Lordship. So, Lordship, the matter may be adjourned today. Taken
You are for?
petition.
You have informed the other side? No. Then wait for your turn. We will let the matter be called for.
May I please, your lordship? Your lordship, item number 7.
Yes.
Your lordship, I have some difficulties today, your lordship. Can it be fixed on Monday or next Wednesday? It's a motion matter. The case is pending. I have an interim prayer. But
Heard
today,
Mr. D. Mondal, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulties. The prayer is allowed. Let this matter be listed on 3rd of October.
highly obliged.
May I please, your Lordship? In item number 59 and 60 of supplementary list, we have filed our affidavit. It is not there on record, so that may be called.
5960 affidavit. Written objection to call for.
So here, item 2.
May I please, your lordship?
Question. Yes.
This is an application, my lord. The person was arrested and he was in custody for 1 month, my lord. Earlier, your lordship has rejected his bail application.
Earlier it was rejected.
Earlier, yes, it was rejected on, my lord, 12 days. Now it is my lord, today is
Then
30 days, my lord.
Case diary would be required.
My lord, I pray for a the short date, my lord. That's my only prayer now.
Okay, heard Mr. A. M. Bora, learned senior counsel assisted by Mr. A. K. Azab,
Is it up?
A. Z. Ahmed, learned counsel for the petitioner. Also heard Ms. M. Das, learned additional public prosecutor. Call for the case diary. When?
Lordship, on 7th,
7th is holiday.
vacation court is there, Lordship.
Before that, my lord.
No,
Huh?
let,
4th,
Fourth?
Lordship,
On 4th, my lord.
4th, Lordship.
okay, on 4th.
Obliged.
Item 3.
It is the lordship. My 483 application. And he was arrested on 10/7/2023, my lord.
21C,
Yes, my lord.
Scan copy, Lordship.
charge sheet has been laid.
Tashit has been laid, my lord.
Heard Mr. M. A. Chaudhary, and counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. Call for the scanned copy of the case record of special NDPS case number 75/2023 from the the Court of London Special Judge Karim Bench, Registry to take steps for requisitioning the scanned copy. Let this matter be listed when? After vacation.
After vacation.
Let this matter be listed again on 4th of November.
4th of November, my lord.
So item 4.
Next, please, Your Lordship. Your Lordship, the plaintiff filed one application for paying for calling for records and original affidavit submitted before the municipality board. And that application was rejected. That impugn order, Your Lordship will find at page 49, Annexure 5. May I read?
Yes.
Plaintiff and defendants number 1, 2, 3, and 4 are represented by learned counsel by petition number so and so. Adjournment is sought due to so and so. Today is fixed for hearing of plaintiff petitioner side on petition number so and so.
What is this petition?
This petition was filed for calling for one affidavit and case records from the municipality and circle office. Lordship.
Okay.
That application I have annexed, that is annexure 4. Lordship. Right, petition number so and so written on plaintiff Bhobiram Das under order 13 rule 10 read with section 151 of CPC has paid for call for one affidavit dated 7/2/2018 from the office of the chairman of Sibsagar Municipality Board and case record of case number so and so from office of the circle. It is contended that the petition contended in the petition that affidavit dated 7/2/2018 executed before Notary Public Sibsagar in connection with Schedule 1 land was submitted before the municipality board Sibsagar. It is also contended that case number SSRC so was registered by the circle office Sibsagar recovery of share of defendant number 1 and 2 out of Schedule 1 land. It is averred that both documents are highly expedient and necessary for plaintiff before adducing his evidence. In the aforesaid petition, only Srimati Junaki Das, defendant number 1, is made opposite party. Defendants had received copies and the said petition of the said petition, but has not filed their filed written objection. Learned advocate Mr. R. Datta has submitted that documents records are denied by the defendants represented by him. Lordship, may kindly note this part, Lordship. From perusal of the petition, it is seen that public officers are custodians of the documents records mentioned therein. Nomenclature of the documents records stated in petition also speak that these are public documents. Order 13, Rule 10 of CPC provides for calling for records from any court. Rule 6 of Order 16 is for summoning any person to produce a document, whereas Rule 7 provides that any person present in court may require by the court to give evidence or to produce any document then and there in his person. So these sections I am skipping, Lordship. Lordship may now kindly turn to page 52. Third paragraph, Lordship. The provisions of the Indian Evidence Act 1872. Lordship.
Yes.
The provisions of the Indian Evidence Act 1872 has made clear regarding proof of public documents. Besides, Rule 106 of the Civil Court Rules and Orders of Guwahati High Court provides that, subject to any provision of the law to the contrary, the original of public and municipal records should not be called for when duly authenticated and certified copies of the same are admissible in evidence and will serve the purpose for which the records are required. As the documents stated in petition are public documents and custodians thereof are not courts, as per law, prayer for directing production of those documents records is not maintainable and hence petitions are rejected. So one citation was given, Lordship. And now Lordship may kindly see that 106 of Civil Court Rules, Lordship.
Yes.
Subject to any provisions of the law to the contrary, the original of public and municipal records should not be called for when duly authenticated and certified copies of the same are admissible in evidence and will serve the purpose for which records are required. So second part will serve the purpose for which the records are required. Now Lordship may kindly see that subclause 3 of the said section. When a copy as aforesaid is produced, the court shall at the time of at the hearing inquire whether the opposite party admits the copy. If the copy is admitted, the original need not be called for. In my case, it is already that I have already pointed out before your lordship that they denied that document. In page 50, fifth line.
Now, we have to issue notice.
And today is fixed for his examination in chief, so that may be state laws, the plaintiff says. The documents are required, otherwise if he submits that with his evidence.
You are plaintiff.
I am plaintiff.
Yes, who is appearing? You are appearing for
I am appealing for 9 and 10 laws.
state.
State law. Optimal defendant law, I am a circle officer lordship.
Okay, heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr.
T.R. Gogoi lordship.
T. R. Gogoi, learned
Lord.
government advocate,
Lordship.
representing
9 and 10 laws.
opposite party number 9 and 10. This application under Article 227 of the Constitution of India has been filed by the petitioner Bhabiram Das, impugning the order dated 12/7/2024 passed by learned Civil Judge Senior Division, Sibsagar, in title suit number 32/2022, whereby the application filed by the present petitioner under Order 13, Rule 10 for calling of certain documents was rejected. Now, learned counsel for the petitioner has submitted that the petitioner had filed a petition under Order 13, Rule 10, read with Section 151 of the CPC, which was registered as petition number 595/2024. Stop. By filing the said application, the petitioner has prayed for following documents. Number 1, an affidavit dated 7/2/2018 from the office of the chairman of Sibsagar Municipality Board. Number 2, case record of SSRC 04/2020 from the office of the circle officer. Learned counsel for the petitioner has submitted that the petition was mainly the petition filed by the petitioner was mainly rejected mainly on the ground that under Rule 106 of the Guwahati High Court Civil Rules and Orders, it is provided that original of public and municipal record should not be called for when duly authenticated and certified copies of same are admissible in evidence. The trial court also observed in the impugned order that the documents sought to be called for are public document and certified copy of the same would suffice the purpose of the petitioner. Stop. And on that ground, the prayer was rejected. However, learned counsel for the petitioner has submitted that in the impugn order itself, it has been observed by the trial court that the counsel for the other side had denied the documents / records mentioned by the petitioner in their petition number 595/2024. So, learned counsel for the petitioner has also submitted that if the opposite party does not admit, no, learned counsel for the petitioner also submits that Rule 106 within bracket 3 of the Guwahati High Court Civil Rules and Orders provides that when a copy of the documents is produced in the court at the hearing, the court shall inquire whether the opposite party admits the copy, and if the copy is admitted, the original need not to be called for. However, in the instant case, the other side has denied the existence of the copy, the existence of the records and documents intended to be called for by the petitioner. Hence, learned counsel for the petitioner submits that the trial court had erred in rejecting the petition number 595/2024 filed by the defendant. Stop. Issue notice to the opposite parties. Since Mr. T.R. Gogoi, learned government advocate, has already appeared for respondent number 9 and 10, no formal notice need to be issued to the said respondent. As regards other respondents, the petitioner shall take steps. Today itself you have to take steps. Take steps for issuance of notice on the remaining respondents during the course of the day by registered post with AD as well as by usual mode returnable on 30 October 2024. In the meanwhile, learned counsel learned counsel for the petitioner has also submitted that the title suit number 32/22 is fixed for evidence of PW before the trial court today itself. So, considering the submissions made by learned counsel for the petitioner as discussed herein above, the what stay you want?
Further proceeding.
It is your claim.
My claim. I have filed.
Further proceeding of title suit number 32/2022 shall remain stayed till the next returnable date. List accordingly.
Madam, one clear with regard to item number 3. Can it be taken up on 24th, Lordship, instead of 4th of November?
24th of
October, madam.
Okay, you have to inform the PP.
I will inform, madam. She
Okay.
got
24th. Item number 3.
on DPO.
Item 5.
Yes.
May I please, Your Lordship? My lord, this revision petition, my lord, has been prepared by this petitioner and challenging an order passed by the learned civil judge junior division Amingao on allowing a application of amendment filed by the plaintiff respondent, my lord. My lord,
You are,
I am the
you are
defendant.
defendant.
Yes, my lord. My lord, the petitioner, they are the defendant and the plaintiff is the respondent hearing, my lord. My lord, the facts of the case of the plaintiff is that, my lord,
Which is the impugn order?
my lord,
Page?
page, my lord, 59. We start from 59, my lord. An application of amendment, my lord, was filed by the plaintiff and that was allowed by, my lord. And against that order, my lord, the defendants, present petitioner, prefer this revision petition, my lord. My lord, before perusal of this impugn order, may I submit the facts of the case here? Here, my lord. The case of the plaintiff is that, my lord, predecessor of this defendant, petitioner, have executed an agreement for sale, non-registered, in the year 2013, my lord, in favor of the plaintiff, in respect of the suit land. Now, my lord, the further case of the plaintiff is that, my lord, that in the year 2016, in respect of the said suit land, the predecessor of the petitioner has executed a general power of attorney registered, my lord, in the year 2016 in favor of the plaintiff, in respect of the said suit land, my lord. On the basis of that general power of attorney, my lord, the plaintiff had executed an agreement for sale with one Ritu Boru in a total consideration of rupees 6 lakhs, and out of which he received an amount of rupees 5,50,000 as advance money, my lord. Thereafter, that for further need of money, the plaintiff approached the Ritu Boru, and Ritu Boru denied to give the other considerations, and he stated the plaintiff that he will give the total consideration after execution of sale deed. Hence, the plaintiff approached the predecessor of the petitioner to hand over the possession of the said land. And before handing over the said land, the predecessor of the petitioner expired, my lord. Therefore, the plaintiff has filed a suit for specific performance of contract and for confirmation of possession in the year 2018 against the present petitioner, my lord. In respect of the, my lord, agreement which was executed in the year 2013. Now, my lord, the petitioner has appeared and contested the suit and filed a written statement. The issues were framed, my lord. The case has been posted for plaintiff evidence. Thereafter, in the year 2020, my lord, due to non-appearance of the plaintiff, the suit was dismissed for default. And on application of the plaintiff, my lord, the suit was again restored in the year 2022. And after restoration, my lord, the plaintiff filed an application under Order 39, Rule 1 and 2, read with Section 151 of CPC, with a prayer, my lord, to not to alienate the suit property to the third party or not to change the nature and structure of the property, my lord. Now, the case starts from here, my lord. The present petitioner, they filed a written objection. In their objection, first they have stated, my lord, that the plaintiff respondent, he was never in occupation and possession of the suit property, my lord.
No, so now you are the defendant.
My lord.
Why the suit was filed by the plaintiff for
specific performance of contract
as well as for
confirmation of possession, my lord.
now they want to change from confirmation of possession to recovery of
Possession and some other facts also, new facts they were inserted, my lord. Therefore, my lord, this injunction order or application of injunction order and written objection is necessary, my lord. Here what happened, my lord? Then objection was filed by the petitioner that the plaintiff respondent is never in occupation and possession. The number 2, that the agreement for sale, which was executed non-registered in the year 2013 by the predecessor of the plaintiff in favor of the my lord, predecessor of the petitioner, my lord, in favor of the respondent, was amicably cancelled, and therefore the predecessor of the petitioner executed a general power of attorney, registered general power of attorney in the year 2016. That agreement which was executed in year 2013, that was cancelled. And after cancellation of that agreement, my lord, that power of attorney was executed in favor of the plaintiff. And on the strength of that power of attorney, my lord, the plaintiff has executed an agreement for sale with one Ritu Bodo, and he received an amount of rupees 5,50,000. Now, the plaintiff has filed a suit with a violation of the law of the land that he claiming the double benefit. My lord, he has received an amount of rupees
No, no. For this revision has been filed?
My lord,
This revision has been filed only
I'm
against the,
coming to that, my lord.
okay.
That injunction petition of the plaintiff was dismissed. They have preferred an appeal. That was also dismissed. After dismissal of the appeal, my lord, they have filed a petition under Order 6 Rule 17, Review Section 151 to amend the plain. Now, my lord, their first insertion of new corporation of facts is that number one, in the year 2017, the plaintiff has returned the amount which he has received from the Ritu Bodo, my lord. My lord, kindly come to their.
No, no. What amendment is sought?
That is, my lord. That the amount which is he admitted in his plea that he has received an amount of rupees 5,50,000 from Ritu Bodo on the strength of the power of attorney. Now he wants to.
At what stage this suit is pending?
Plaintiff evidence, my lord.
Issues are framed.
Frame, my lord. Now, my lord, kindly come to page number 48. This is
No,
my
what
lord.
amendment is sought?
That is, my lord. I am coming to that, my lord.
Yes, no, you directly come to that.
My lord, my lord.
What amendment is sought?
My lord, the plaintiff wants to incorporate the facts that he has returned the amount which he has received from Ritu Bodo. Kindly come to page number 48, my lord.
What is this?
My lord, earlier he stated that he has received an amount from Ritu Bodo on the strength of the power of attorney, which was executed by the predecessor of the petitioner. And now plaintiff wants to submit that, my lord, that the amount which he has received from Ritu Bodo on the strength of power of attorney, he has returned the amount in the year 2017. My lord, here the plaintiff has failed to show any valid reason why he has not inserted this paragraph, because the suit was filed in the year 2018, and he stated in his amendment petition that he has returned the amount in the year 2017. Our objection is that he is claiming the double benefit, my lord. And the other fact is that in the previous plain, my lord, the plaintiff has failed to incorporate any averment regarding his willingness and readiness to.
No, amended plaint has been filed.
No, my lord. That is why
No,
I am before your lordship, my lord.
But the order was made.
The next date is, my lord, on 27, my lord. 27/9, my lord. He wants to amend, my lord, that earlier in the plain, there is no such specific averment regarding his willingness and readiness to perform his part of contract, my lord. Now, through this amendment, he wants to incorporate the facts, my lord. The precondition.
How it will change the nature of the,
My lord,
or how it will prejudice you?
my lord, here, my lord, what I have understood, my lord, that the prerequisite condition for filing a specific performance of contract, there must be some willingness and readiness of the plaintiff, my lord. But the plaintiff in his plain nowhere is stated about his willingness and readiness to perform his part of contract, my lord. My lord, as it is a prerequisite condition as provided under section 16(c) of the Specific Relief Act, my lord.
I heard Mr. D. Haloy, learned counsel for the petitioner. This application under Article 327 of the Constitution of India has been filed by the petitioners impugning the order dated 9/7/2024. Passed by learned Civil Judge Junior Division Kamrup Amingao in title suit number 46/2018, whereby the petition filed by the respondent praying for amendment, petition filed by the respondent under Order 6, Rule 17, read with Section 151 of the CPC, praying for amendment of the plain was allowed by the petitioner. Your main objection against this allowing of amendment is, number one,
Number one, my lord, that the plaintiff has failed to show any valid reason why he has not inserted the fact that he has returned the advance amount which was received by him from Rituboro in the year 2017, number one. And number two, my lord, the prerequisite condition of the filing a suit under specific relief, specific performance of contract, that he has willingness and readiness to.
learned counsel for the petitioner have submitted that the amendments sought for by the respondent in his claim, which has been allowed by the impugn order, is only aimed at filling up of the lacuna in the plaint at a belated state by the respondent side. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 25th of October 2020. 24. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as well as after going through the application and supporting documents filed by the applicant, the operation of order dated 9/7/2024 passed in title suit number 46/2019 shall remain stayed till the next returnable date.
Highly ordered.
I think this.
Maybe. My lord, a suit was, my lord, the subject matter my lord, of the case is that, my lord, a suit was filed by the respondent, my lord, herein, who is the plaintiff, my lord, before the trial court, my lord. My lord, he is claiming right title and interest, my lord, over a plot of land. And my lord, the basic contention of the defendants, my lord, the defendants being the authorities under the Union of India Defence Estate Office, my lord. They said, my lord, their contention was that the land falls within the defense line. My lord, the area which the plaintiff is claiming as a right title interest, my lord, it was notified as a defense land since, my lord, prior to the independence. That was the basic contention, my lord, of the defendants. Now, my lord, during the pendency of the suit, my lord, on an application made by the, my lord, petitioner, my lord, an order was passed under Order 26 Rule 9, my lord, for commission. For commission, my lord, to examine, my lord, in presence of both the parties, circle officer, all the officials will be there, and a joint survey report was directed to be submitted. My lord, that order is at, my lord, page 25. my lord, it starts from, and the relevant portion, my lord, is page 30, my lord, last paragraph, second last paragraph on this. Page 30. If I may read, my lord.
Yes.
However, at the greater interest of justice and for shedding light on the matter in dispute, a joint resurvey of the suit land is found to be the need of the hour, as the resurvey will not prejudice any party to the suit. Rather, it will assist and aid this court to elucidate the matter in dispute. The report obtained in the instance of the court shall be made part of the record, and the parties will get an ample opportunity to conduct hearing on the same. Accordingly, in exercise of power under Order 26 Rule 9, this court directs a fresh joint survey of the concerned land in presence of both the parties. The circle officer of the Telamara Revenue Circle is hereby appointed as the survey commissioner to conduct the joint survey in presence of all the concerned parties and defense personnel as per the procedure of law. Also, in the opinion of the court, it would be prudent to direct the different number 1 to A, B to bear the necessary cost for issuing the commission. Thereafter, my lord, the commission was issued. Next page, my lord, we'll see, page 32.
Yes.
Commission was issued, my lord, notice was issued under the orders of the court. And my lord, 3 questions were, my lord, you'll see at CL number 1, 2, and 3, that was made part of the summons. Whether what portion of the land is under possession of the defendant, defense, public road, and plaintiff, Mr. Jalaluddin, whether the defendant, defense have encroached on any portion of the land of the Mr. Jalaluddin, and if yes, to what extent? And my lord, whether the plaintiff have encroached any of the portion of the land of the defendant, defense, and if yes, to what extent? Now, thereafter, my lord, the survey was also conducted. The survey was also conducted, my lord, and now the present stage is, my lord, that it is waiting for the final report. Then, my lord, subsequently, what happened at page 39, my lord, will see. Page 39, my lord, the circle officer, my lord, by a communication, my lord, sought for more, some time to submit the final report. Pursuant to the direction of resurvey was also conducted, my lord, and now it was for submission of the final report. Now, my lord, pending the final report, my lord, as the report has not come, my lord, we have filed a petition, page 40, annexation 9. Next page, my lord. My lord, page 41 is the prayer that, my lord, we have prayed that till the final report is submitted, the court should not proceed with the further hearing. Now, my lord, this petition was rejected, leading to passing the impugn order, my lord, at page 44. Page 44 is the, my lord, impugn order. And the grounds for rejection of the plaintiff, my lord, the petition is, my lord, in the next page at page 45, second last paragraph. My lord, we take from the third paragraph.
What is the wrong in this ground?
My lord, once the court has ordered for commission and the survey has.
Commission will only help the court. Commissioner's report will only help the court.
Yes, my lord. Now, without that commissioner's report, my lord, the trial court is proceeding for the arguments. Once, my lord, there is a judicial.
At what stage it is pending?
It is for the arguments, my lord. The court has rejected our petition, and without taking into consideration, without waiting for the report, my lord, there is a letter on record, my lord, categorically requested by the circle officer, praying for time to submit the report. Survey has been completed already. My lord, once there is a judicial order, that has to be complied with, my lord, and the report has to be on record, my lord, before the.
How you will be prejudiced if argument is held?
My lord, if the report, my lord, clearly says that the land falls within the defense land, my lord, the matter ends there, my lord, then the arguments can start. Without, my lord, waiting for the report, if the argument is started, my lord, we will be highly prejudiced. There is already an order, my lord, directing a commission.
Heard Mr. A.K. Gupta,
H. Gupta.
H. Gupta, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, by the petitioners, who are the defendant number one, who are the defendant number one and
My lord, 1A and 1B.
1A and 1B in the title suit number 106 pending before the Court of Learned Civil Judge Junior Division number 124, impugning the order dated 6/7/2024 passed by the said court in the aforesaid title suit. Stop. Stop. Learned counsel for the petitioner has submitted that on an application for commissioner, you made the application
Yes, yes, my lord.
on an application made by the petitioners
Order 26, rule 9.
under Order 26, Rule 9 of the Code of Civil Procedure, with which, where is the order appointing the commissioner?
Page 31, my lord.
The trial court
That's correct.
by order dated 8/1/2024
18-1, my lord.
18/1/2024 appointed a survey commissioner, appointed the circle officer of Thelamara Revenue Circle to appointed the circle officer of Thelamara Revenue Circle as survey commissioner to conduct a joint survey of the disputed land with to ascertain 3 points, namely, number 1, what portion of the land is in the possession of defendant, defendant defense, public road and plaintiff Mr. Jalaluddin. Number 2, what the defendant, whether the defendant has encroached on any portion of land of the plaintiff, if yes, to what extent. Number 3, whether the plaintiff has encroached on any portion of land of the defendant. If yes, to what extent. This has to be decided by the court, not by the.
Yes, my lord, it has to be decided by the court, but my lord, a joint survey was
Stop.
directed to be done.
After issuance of the report of the, after issuance of the writ regarding commission of the regarding survey of the disputed land by the commissioner appointed by the court,
On 1/7, my lord, it was,
the
survey was done.
it is submitted by learned counsel, it is submitted by learned counsel for the petitioner that the survey has been conducted on
1/7/2024.
1/7/2022 and
Final report is awaited, my lord.
and the final report of the commissioner is awaited. In the meanwhile, as the suit is pending at the stage of argument, at the title suit number 106/2014 is pending at the stage of argument, the petitioner had filed an written object, filed an application for staying the further proceeding of the suit till the receipt of the report of the survey commissioner who was appointed by the court, however, by the impugn order dated 6/7/2024, the trial court rejected the petition and fixed the case for argument. Now, whether on 6/8 argument was held,
No, my lord.
when is the next? date?
11/11, my lord. So 12/11/2024.
Before that, the report may be submitted because it is a long date.
My lord can dispose it of, my lord, also with a direction that the report be called for and my lord matter can be proceeded. In that case also I have no objection. Our only concern is that, my lord, since once the joint survey has been directed, the report should
No.
be taken into consideration.
Notice has to go. What was the last line? Argument, learned counsel for the petitioner has submitted that if the trial court proceeds with the argument without considering without waiting for receipt of the report of the commissioner appointed by the court, the petitioner would be highly prejudiced. So, issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD. Return, as well as by usual mode, returnable on, when is the next date?
My lord, 12/11/24.
Returnable on 4/11/2024. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed herein above, as well as considering the materials available on record, further proceeding of title suit number 106/2014 is hereby stayed.
Hello.
List accordingly.
Item 59 and 60 from supplementary is coming.
Lordship, my senior is on legs. Kindly pass over the method for time being, Lordship.
Awesome.
Item 61.
Same pair, Lordship.
Ordered item 18 to 25.
With the Lordship. And for the appellant, but my name hasn't been shown in the causally, so many dates I could not appear.
You are for?
Appellant, Lordship.
What is your name?
Northeast Contrary.
What is your name?
S. Chakraborty.
You are for railways.
Yes, Lordship.
So what is your prayer?
There is actually personal appearance, some officers has come and affidavit earlier I have to file an additional affidavit, but
Record.
um,
No, what is your prayer today?
maybe just 66,000. Revised statement is the additional affidavit I have filed on behalf of the NFL. 66,126 is payable this amount, Lordship. So many respondents address could not be found, and some of the respondents is appeared. So like this, so only 66,000.
No, whether now the question is whether have you taken steps for issuance of notice on the respondents? Even if they don't appear,
Yes,
we can proceed ex parte.
but I have taken the steps, Lordship. But as
But record shows that you were not appearing on several dates.
yes, my name has not been shown in the COSLI, so that's why the problems could not appear.
Okay, you are the standing counsel or engaged counsel?
The railway,
Railway advocate.
yes.
Your wakalatnama is there.
Yes, Lordship.
Okay. So,
Earlier, my name has showed, but so many days my name has not been shown.
the matter was sent to Lawazima Court in 2018.
Yes.
What was the order passed? As per Lawazima case, order that is
As per laws order, I have taken the steps.
separate orders have to be passed. Today we are directing that to show your name in the cause list. You go through.
No. Then standing counsel Uma Chakraborty informed me your case is listed, so
No, we are directing that
yes.
henceforth your name will be shown in the cause list. You go through the record because you have to take steps. Some of the respondent might have died.
Yes.
Substitution may be required in
Yes.
for respondent number 1, 2, 3. In some cases, the service, the reports have returned with notice answer. Next item, the option. Next. One by one, separate orders. Third, Miss S. Chakraborty, Learned Counsel appearing for the appellant. Appearing for the applicant / appellant. Miss Learned Counsel has submitted that since the name of the counsel, Miss S. Chakraborty, has not been reflected in the cause list since last many days when the matter was listed before the court. She was not aware of the listing of the present appeals and therefore could not appear before the court on earlier dates. Today also, she has been informed by the and other standing counsel of the railway regarding listing of the case. Stop. On perusal of the report of on perusal of the office note dated 26/4/2024, it appears that the notices issued to respondent number 1, 2, and 3 have returned with an endorsement within inverted comma deceased. Stop. In view of the above endorsement, the applicant the appellant shall take. Is there any IA? No, the appellant shall take steps for what for miscellaneous cases are there?
Earlier advocate is filing witness for delay. So it is disposal.
Disposal, no? But it is shown in the first list. What was the last one? And take appropriate steps in view of the report that the respondent number 1, 2, and 3 have passed away. You take steps.
After Puja vacation.
The
For you.
the counsel for the appellant seeks some time to take the necessary steps.
Lordship, I am appearing in item number 20 and 24 for the respondent.
Okay, we are yet to reach the
Oh.
My lord, in this series, my lord,
20 and 20.
state is the respondent in all the matters, but in the first list, nowhere it is showing the state respondents.
learned counsel for the appellant has prayed for some time to take appropriate steps. The prayer is allowed. Stop. Mr.
Jay Singh, my lord.
Jay Singh,
Government advocate.
learned government advocate submits that the state
2024.
is respondent number 4 in this case. However, the name of the government advocate has not been shown in the cause list against this case. Stop. It is hereby directed that name of Miss S.
As GA or something.
No, just a minute. Name of Miss S. Chakravarti shall be shown as an engaged counsel for the appellant in the cause list henceforth. Similarly, name of
Government advocate Assam. my lord.
government advocate Assam shall be shown as
Respondent.
counsel for respondent in the cause list henceforth.
Lordship, I am appearing in item number 20 and 24 for the respondent number 1.
Yes, we are going one by one.
Lordship.
So it is 8, 19, item number 19.
18, 19.
Miss S. Miss,
Yeah.
you are not appearing in other cases.
No, Lordship. Only in 20 and
S.
24.
Chakravarti, learned counsel for the appellant, appears for the no, Mrs. Chakravarti, learned counsel for the appellant has submitted that her name has not been shown in the cause list and requests that same may be done. Mr. Jay Singh,
My lord.
Jay Singh, learned government advocate, also submits that the name of government advocate is also not reflected in the cause list, though the state is a state is the respondent number 2 in this case. The registry shall show the name of Ms. S. Chakraborty as engaged counsel for the appellant as well as Government Advocate Assam as the counsel for the respondent number 1,
Two, my lord.
respondent number 2 in the cause list henceforth. It appears that it appears from office note dated 26/4/2024 that as per the Lawazima Court's order dated 9/4/2018, service on respondent number 1 is deemed to be complete. Stop. Hence, it is hereby held that service on respondent number 2 is complete. Then this will go for hearing.
Go for him.
Let this case be listed for hearing after Puja vacation on a date to be fixed by.
They may be directed to the furnish us with extra copies now.
Yes, yes. I'll give.
Formal order is required or you will furnish.
I don't will be required otherwise.
The appellant is directed to furnish copies of the memo of appeal along with the annexure to the learned government advocate within 2 days from the date of this, within a week from the date of this.
Yes.
Item number 20. Heard Ms. S. Chakraborty, learned counsel for the appellant, who submits that her name has not been shown in the cause list and prays for doing so henceforth. Also heard Mr. J. Singh, learned counsel for the learned government advocate, appearing for respondent number 2. He also submits that name of government advocate Assam may be reflected in the cause list as engaged counsel for the respondent number 2. The registry shall do the same by reflecting the name of Ms. S. Chakraborty as counsel for the appellant as well as reflecting the name of government advocate Assam as engaged counsel for respondent number 2 in the cause list henceforth. None has appeared for respondent number 1.
Respondent number 1, Lordship, in item 20, I am appearing.
Okay, what is your name?
Lordship M. Devi.
Miss M. Devi.
Senior counsel, Mr. N.C. Das is also.
I am also appearing, my lord.
Or Mr. N.C. Das, learned senior counsel assisted by Miss
M.
M.
Devi.
M.
Devi,
Devi.
appears for respondent number 1. This matter may be listed for hearing.
My lord, it is actually last occasion the matter came up for hearing, my lord. But on the day the counsel for the appellant was not present, my lord.
Okay. No, because her name was not shown in the cause list.
Maybe, my lord.
Let this matter be listed for hearing on a date to be fixed by registry after Puja vacation.
Well,
Direction will also be given for furnishing a memo in this matter.
The appellant shall furnish a copy of memo of appeal along with the annexures to the government advocate.
Lordship, I have the additional affidavit, but this additional has been tagged this in this cases.
When have you filed?
11/11/2019, additional affidavit is the revised statement. But this only affidavit is tagged, but additional affidavit has not been tagged. So kindly please
The registry shall, learned counsel for the appellant has submitted that the appellant has submitted an additional affidavit on 11/11/2019, but same is not found in the case record. The registry to tag the same along with the case record on the next date fix. Item number 21. Heard Miss S. Chakravarti, learned counsel for the petitioner, applicant Mr. N.C. Das, learned senior counsel assisted by Miss
M. Devi, ma'am.
M. Devi, learned counsel for the respondent number 1, as well as Mr. J. Singh, learned government advocate for respondent number
21. 21, Lordship, we are not appearing. In item 21, we are not appearing.
N.C. Das.
Yeah.
In item 20.
None has appeared for
Respondent.
respondent number 1. Though from the office note dated 5/5/2019, office note dated 26/4/2024, it appears that the notices issued to respondent number 1 has been duly served. So let this case be listed for hearing on a date to be fixed by registry. Let the name of Ms. S. Chakravarti be reflected as engaged counsel for the petitioner in the cause list henceforth. Let also the name of government advocate Assam be reflected in the cause list as engaged counsel for respondent number 2 in henceforth. The appellant is directed to furnish a copy of memo of appeal to the learned government advocate before the next date fixed. Let this case be listed after puja vacation for hearing on a date to be fixed by registry. Wait, you are in 22.
24, Lordship.
24, my lord.
22 also.
Kami naik. Itu naik. Hmm.
22, how many respondents are there?
22.
6 are there.
Heard Ms. S. Chakravarti, learned counsel for the appellants. Also heard Mr. J. Singh appearing for respondent number 6. From office note dated from the order of the Lawazima Court dated 9/4/2018, it appears that notices issued to all the respondents are duly served. Hence, let this matter be listed for hearing on a date to be fixed by registry after puja vacation. Let the name of Ms. S. Chakravarti and government advocate Assam be shown as engaged counsel for the appellant and respondent number 6 respectively in the cause list henceforth. The appellant shall furnish a copy of memo of appeal to the learned government advocate before the next date fix.
22.
Heard Ms. S. Chakravarti, learned counsel for the appellant, as well as Mr. J. Singh appearing for respondent number 2. None has appeared for respondent number 1. Respondent number 1 has expired. You have to take steps. Perusal of the office of the on perusal of the order dated 28/9/2018 passed by Lawazima Court, it appears that the respondent number 1 has reported to have expired as, and therefore the appellant shall take appropriate steps. And because the appeal is otherwise abated against respondent number 1. In 18, he has expired. You have to take necessary steps. Stop. Learned counsel for the appellant prays for some time for taking appropriate steps with regard to the respondent number 2, respondent number 1, and prays for some time for the same. The prayer is allowed. Let this matter be listed after puja vacation.
System, quality system.
You are in 24.
Yes.
Heard Miss S. Chakravarti. Appellant also heard Mr. N.C. Das. Learned Senior Counsel assisted by Miss M. Devi. Learned Counsel for respondent number
1 and 2.
1 and 2, madam.
1 and 2. 1 and 2. Mr. J. Singh, learned government advocate, appears for respondent number 3. Let this case be listed for hearing after puja vacation on a date to be fixed by registry. The appellant is directed to furnish a copy of memo of appeal along with the annexures to the respondent number 3, to the engaged counsel for respondent number 3. In 24, what is this miss case? There is a miss case. Miss case has been disposed of.
Yes.
So 1908.
MC.
Did I do?
Because earlier orders are passed, only single orders are passed.
Yes, common orders.
But
Common.
case
এখানে খালি মিলে দিবো।
Mislead করে তাহলে যায় না, common order করা।
oh,
24 है। MC
delay has not yet been condoned.
delay has not been done. Yes, I is still there.
In
4, madam. 24 है।
24 হতে আইছে হয় না?
Yes. But as per the cause this one, it is 24, I think.
24.
Delay confirmation. Delay confirmation.
Agor case put likibo. In 24, we will hear the miss case on next day. And the appeal common order for miscase and LA appeal in item number 24. Instead of hearing the LA appeal, we'll hear the miscase on the next. Item number 25. 25. Heard Ms. S. Chakravarti, learned counsel for the appellant. Also heard Mr. K. Singh appearing for
Respondent 4 months.
respondent number 4. You have to take steps for issuance of notice on respondent number 2 and 3. It appears that the appellant has not taken steps for issuance of notice on respondent number 2 and 3 as directed by Lawazima Court earlier. Stop. Learned counsel for the appellant prays for some time for taking steps for issuance of notice on respondent number 2 and 3. Prayer is allowed. The appellant shall take steps for issuance of notice on respondent number 2 and 3 by registered post with heading within 7 days from the date of this order, returnable after 4 weeks.
Item 26.
Not needed.
Itu Kuraidyo. Ms. Chakravarti, you take back that document to Kuraidyo. You can submit it later on. Yes.
Your Lordship, in this case, service is completed. LCR also received. And we fixed
It
it
is
for
ready
hearing.
for hearing. Heard Ms.
P. Hujuri.
P. Hujuri, learned counsel for the appellant. Also heard Ms. A. Burman, learned counsel appearing for respondent number 1.
Respondent number 1.
Anybody appearing for 2 or 3?
I have no knowledge.
The parties,
Party, Bakratama file. Between the respondent number 2.
none has appeared for respondent number 2. Let this case be listed for hearing after puja vacation on a date to be fixed by registry.
Okay. Yes.
Item 27.
May it please your Lordship. Lordship will peruse office note dated 29/8/24 Lordship. Service on 2 is also complete. And this is a delay petition.
One.
One already Lordship, office note dated 13/2/23 AD on R1 signed by Subhas Das. Flag A. Then by that we had not taken step by usual process. So we thereafter we took steps by usual process, and the last office note is 29/8/24. This SR R2 received and signed by his wife. Flag service report. Flag is service report.
It has been received by his wife.
Yes, Lord. He is the owner of the vehicle, Lord. So this is a MSA. So only 2 respondents with him. And delay is only of 12 days, Lordship. And from 2015, it is pending for just service, Lordship.
Who is Subhash Das?
Subhas Das is brother of Pradeep Kumar Das.
Okay. After registration of the appeal, you have to take fresh steps.
That will be after.
Then we are disposing of the one.
Lordship can dispose of this.
Heard Miss R.D. Majumdar, learned counsel for the petitioner, learned counsel for the petitioner. On perusal of the office note dated, how you came to know that Subhash Das is brother?
Lordship. I do not know, Lordship, somehow.
On perusal of the office note dated 13/2/2023, it appears that the AD card of the notices sent to the respondent number 1 through registered post with registered post has returned. Stop. It also appears that the notices sent by usual mode to respondent number 2 has returned with a report that the notice has been received by the wife of the addressee, that is respondent number 1, respondent number 2. Stop. In view of the reports, the notices are held to be duly served on both the respondents. This, we will fix another date.
Lordship, from 2015, this case is pending, Lordship,
The
just.
notices are held to be duly served on both the respondents.
12 days only, Lordship.
Heard learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of 12 days in filing the connected
MFA.
appeal, whereby the judgment dated 15/7/2014 passed by the Commissioner Workmen Compensation Bajali Subdivision, Borpeta in WC case number 76/2013 has been impugned. Stop. After hearing learned counsel for the applicant and after where are the
3 to 8, Lordship, paragraph
after
3 to
considering the grounds mentioned in the application filed by the applicant, this court is of considered opinion that the delay of 12 days in preparing the connected appeal has been sufficiently explained by the applicant, and therefore the said delay of 12 days is hereby condoned, and this misapplication and this miscase is accordingly disposed of. The registry is directed to register the connected MFA and list the same for admission within a day,
next week.
in the next week.
Highly obliged.
I'm taking some
Steps.
What is the report? You have gone through office note. We have to await further. We'll await report. Heard Mr. What is your name?
MK Dev.
MK Dev, learned counsel for the appellant. Also heard Mr. H. Pura Bohai, appearing for respondent number
1, Your Lordship,
Respondent
insurance company.
1. On perusal of the office note dated 21/9/2024, it appears that the notices sent to respondent number 3 has not yet returned back. Return back. So await further for the service report. list this matter after Puja vacation.
In item number 29, Your Lordship, I am for the appellant, insurance company, Your Lordship. In this case, Your Lordship, the claimants are before this honorable court, and our main grounds is on the quantum. So I am praying for that the other respondents may be struck off, Your Lordship.
Insurance company has filed case for
For the quantum, Your Lordship,
decreasing the quantum.
decrease in the quantum.
Okay. Heard Mr. H. Buragohai, learned counsel for the applicant, learned counsel for the appellant. Also heard Mr. What is your name?
MK Dev.
N.K. Dev, learned counsel for the respondent number
1 to 4 claimants, Your Lordship.
1 to 4 claimants. Learned counsel for the appellant has submitted that already struck off.
Lordship, in that case, Your Lordship, the matter is ready for hearing, Your Lordship. LCR
Learned
has also
counsel
been-
for the appellant has submitted that the matter may be heard as it is ready for hearing. Let this case be listed for hearing on a date to be fixed by registry after Puja vacation.
Deeply obliged.
Item 30.
Yeah, please, Your Lordship, in this case, on the last day, we were directed to take steps upon respondent number
This
14.
is delay condonation,
Yes, Your Lordship.
delay condonation.
Yes, Your Lordship.
You have taken steps.
Lordship, we were supposed to take steps on respondent number 14 by way of Dusty. But Your Lordship, actually, respondent number 14 has, the name of respondent number 14 has already been substituted during the pendency of the title appeal, Your Lordship. So we may be allowed to correct the cause title and take fresh steps upon the respondent number 14.
Cause title means you want to
Because we incorporate the name of son of late Narayan Chandra Saha. That is Shri Ratan Saha.
you have to file an application for this.
Yes.
You file an appropriate application.
Okay, okay.
Heard, Mr. What is your name?
D. Akram, Your Lordship.
D.
D. Akram.
Heard, Mr. D. Akram, learned counsel for the applicant. Also heard Mr. R.K. Jain, learned counsel, appearing for respondent number 1, 2, 4, 6, 8.
1, 2, 3, 4, 6,
1, 2, 3, 4, 6, 8, 13, and 17.
15 and 17.
15 and 17. 1, 2, 3, 4, 6, 8, 15, and 17. Also heard Mr. Jay Singh, a learned government advocate, appearing for respondent number
19 to 23.
19 to 23, as well as Mr.
RS.
R.S.
Number 11.
R. Islam for respondent number 11. Learned counsel for the petitioner has learned counsel for the applicant has submitted that as respondent number 14 has already expired, hence appropriate steps may have to be taken by the applicant for have already expired during the pendency of the title suit.
Title appeal, Your Lordship.
During the pendency of the title appeal.
But the name has already been substituted in the title appeal, Your Lordship.
Okay. Hence, the cause title of the present appeal may have to be amended, and for which he intends to file an appropriate application. And some time has been prayed for the same. The prayer is allowed. How much time will you require?
2 weeks, Your Lordship.
Let this matter be listed after Puja vacation. The applicant may take appropriate steps in the meanwhile.
IA is there for condonation. Same application will give.
No, this is in the IA only. Because the appeal is yet to be registered.
Item 31.
May I please, your lordship? My lord, I am not counsel in this case, my lord. On request of Mr. H.R. Ahmed, my lord, he is out of station. So matter will be adjourned today. He requests me over phone, my lord.
Heard Mr. N. Uddin, learned counsel appearing on behalf of Mr. H. R. Ahmed, learned counsel for the appellant, who prays for an adjournment. None has appeared for the respondent side. The prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by registry.
Item 43.
I am blessed.
Will be pleasure, lordship. Lordship, in this case, I am appearing on behalf of sole respondent. My lord, as per the last order dated 8/5/24, the appellant direct to provide a copy of memorandum of appeal, but we did not get any copy, my lord.
Okay,
Today,
provide,
today.
provide.
My lord, in this meantime, we file objection in this matter. my lord.
Written objection.
Yes, lordship.
No, this is an appeal. Appeal against what?
Appeal
Railway.
against my
Okay,
original
let
application.
them file objection. Heard Miss A. Gayan, learned Central Government Council,
Yes,
appearing for the appellant. Also heard Miss
M. Kolita.
M. Kolita, learned counsel for the sole respondent. Sole respondent?
Yes, sole respondent.
Sole respondent. Learned Central Government Council has furnished a copy of memo of appeal to the counsel for the respondent today itself. Has already furnished the copy of memo of appeal to the counsel for respondent today. Stop. Learned counsel for the respondent has prayed for some time for filing a written objection against the
IA, my lord.
in the IA. For what purpose IA is there?
Stay of my lord, order dated 13/5/2020. There is a stay, my lord, in I.
In this case, this may be, the records may be necessary.
Yes, my lord.
Let the records of
OA number 253 of 2011.
OA number 253 of 2011
Before Railway Claim Tribunal.
be called for from the Railway Claims Tribunal, Guwahati bench. 253 or 255?
Sorry, 255.
255 of 2011 be called for Railway Tribunal. In IA, write the name of the council. Learned counsel for the opposite party prays for some time for filing written objection against the application made by the applicant in this case. The prayer is allowed. Let this case be listed after puja vacation.
Okay.
Item 44.
Wait, please, your lordship. Lordship, with respect to respondent number 2, answer of notice has come back, lordship.
You have to take
We have to take fresh steps, lordship.
why it has not been served.
The period was over, it was written. Lordship, LCR has also come, but it has not come with the court file, lordship. It's with the section.
Heard Mr.
HR.
H.
R. Das.
H.R. Das, learned counsel for the appellant. Also heard Mr. H.
E. Dole.
Mr. A. Dole,
Respondent number 1.
appearing for respondent number 1. Who is respondent number 1? Okay, respondent number 1. On perusal of the office note dated 16/9/2024, it appears that the notices sent to respondent number 2 has returned without service. Have returned without service. Stop. The endorsement shown in the postal report is within inverted comma expired. You have to take steps. In view of this above, learned counsel for the appellant seeks some time for taking appropriate steps with regard to respondent number 2. The prayer is allowed. Let this matter be listed after Puja vacation. In the meanwhile, the appellant may take appropriate steps with regard to respondent number 2, who is reported to be expired.
I is filed by.
Reported to have expired. Reported to have expired. Yes. What is this I for?
Lordship, this I has been filed for releasing the 50% amount deposited by the appellant insurance company, Lordship.
We have filed our objection, Lordship. My prayer will be, Lordship, since the service is complete, LCR is received, finally the case can be heard. And if they get, it will be, because we are alleging fraud in the case, Lordship. There was no postmortem report. There was nothing to connect the death with the injury, Lordship. So it can be fixed for hearing because
We'll
next
hear
week
it.
is.
Date may be fixed, your Lordship.
Yeah, we are fixing
Yes,
it.
yes.
Lordship, can it be in November? Because already October after opening, so many cases are fixed, Lordship.
November, choose a date.
Apuni কওক যিটো কয় নাই নাই যিটো কয় মোৰ আপত্তি নাই
No. November first week, any day.
MSc 3 main case of
ফার্স্ট
Likibo.
উইকত নাই দেখো 1-2 তারিখ বন্ধ হবে
What should we do to IA?
it
There
can
may
be
be kept pending, Lordship.
Okay.
or it can be taken up with the final hearing that order can
Yes.
In IA,
12 তারিখ ঠিক আছে 12 November 12 November Lordship 12 November
in IA Likibo. Learned counsel for both the sides are present. No, Mr. What is your name?
A.R. Shom, Lordship.
Mr. A.R. Som, learned counsel for the appellant. Also heard Miss Adi Majumdar appearing for respondent number 3 and 4. And Mr. S.S. Borua appearing for respondent number 2. As the MSc case number, MSc appeal number 3/2019 has been fixed for final hearing on 22nd of November. This
22nd is 12
12,
22nd Friday.
22nd Friday Lordship
Okay.
12 we agreed on 12 November
on 12th of November. This interlocutory application may be taken up at the time of may be taken up for consideration at the time of final hearing. Stop. In MSc case, MSc main case of Likibo, but counsel now make it Likibo. With consent of learned counsel for both the sides, let this matter be listed for hearing on 12th of November 2020.
Oblige, your Lordship.
highly obliged sir.
Your Lordship. Your Lordship, as per order dated 18/9/2024, the opposite parties were supposed to file objection, Lordship. But no such objection has been received.
What is the interlocutor application?
It is for stay, Lordship.
What is to be done?
My stay may be considered, Lordship. I-
No, we'll give one more opportunity. We'll hear that this matter on next date. Heard Miss, what is your name?
B. Hazarika on behalf of R. Jaiprakash.
B. Hazarika Learned Counsel for the applicant. None has appeared for the opposite parties. Let this case be listed again after Puja vacation on a date to be fixed by registry.
Plus.
Item 40.
May I please allow? The revision application.
Now, why this interlocutory application?
Pardon, my lord?
This interlocutory application is for, this is
No, I have not filed any interlocutory application.
item 40. Itu belek case naki.
This is Hardeep Singh Matharu
Item-
versus Sukhjit Kaur.
This is MFA 12 by USA. Item 40 is CRP,
Yes.
wrong case. Na bhul likhi se. We don't have the files. We'll call it after some time.
Madam, I am appearing on behalf of 127, 71, 72, and 73. Appeal was already admitted. LCR was, I think, madam, received.
Okay. None has a
There's a concurrent findings, madam.
None has appeared for the appellant on call. Mr. A.K. Purkayastha, Learned Counsel for the respondent number 1.
1 to 7, 71,
Respondent number 1 to 7,
71, 72,
comma,
and 73.
71, 72, and 73. Is present. On perusal of the office note dated 6/9/2024, it appears that notices sent to respondent number 8 and 9 have returned without service. The appellant is directed to take fresh steps for issuance of notice on respondent number 8 and 9 by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable after 4 weeks. List accordingly. Is there any IA?
IML, I think, my lord. I was not supplied with any copy of IML. I don't think, my lord. But once the appeal is admitted, perhaps, my lord.
Item 14.
No.
No. IA Kunda, IA 9. You have to take fresh steps on, what is your name?
P. Bora Lordship.
Show the name of Miss P. Bora for appeal. You have to take fresh steps on respondent number 8 and 9 within 7 days. List after 4 weeks.
May I please, your lordship? Also, the petitioner is seeking transfer of a divorce proceeding from the Learned District Court of Jorhat to Dibrugarh, your lordship. I need some time to file my reply, your lordship.
Okay. None has appeared for. Heard Mr. M.H. Ali, Learned Counsel for the petitioner. Also heard Mr.
R. Yasin, lordship.
R.
R. Yasin.
R. Yasin, appearing for the respondent, who prays for some time for filing written objection. Prayer is allowed. Let him file written objection.
Lordship, can be fixed after Puja vacation.
Yes, let this case be listed after Puja vacation on a date to be fixed by registry.
Highly obliged, Your Lordship.
So this is appeal against quantum compensation.
What this IF is for?
Lordship, this, no, Lordship, it has come for the first time, it should have come for admission, Lordship.
No. There is an IA. IA has been disposed of.
The I for stay only here.
Order 14 Rule 5.
It hasn't
We'll-
been admitted, Lordship.
We'll admit it.
Yes, Lordship.
It's subject to payment of 50% payment, my lord, awarded amount.
I agree to that.
50%? Okay.
Person
Third,
like it's
Mr.
a very big amount.
Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. What is your name?
F.L. Oskurman.
F. A. Lusper, appearing for the
Respondent number 1, 1, 3, 4, and 5.
appearing for respondent number 1, 3, 4, and 5.
Who has already died, my
1, 3, 4, and 5. Who has died?
died, my.
He also submits that respondent number 2 has already expired. Stop. This appeal has been filed by the appellant under Section 173 of the Motor Vehicles Act, 1988, impugning the judgment and award dated 2/5/2024 passed by learned member Motor Accidents Claim Tribunal, Sirang, in MSC case number 6/2023. You are challenging the quantum only.
Only.
The appellant insurance company is aggrieved with the quantum of the compensation awarded in favor of the respondent number 1 to 5. Stop. This appeal is admitted for hearing. Issue notice to the respondents. Since respondent number 1, 3, 4, and 5 has appeared, no formal notice need to be issued to respondent number 1, 3, 4, and 5. As regards the respondent number 6, 7, 8, and 9, the appellant shall take steps for issuance of notice on respondent number 6, 7, 8, and 9 by registered post with AD as well as by usual mode. Stop. Within 7 days from the date of this order, returnable after 4 weeks. As regards respondent number 2, who is reported to have expired, the appellant shall take appropriate steps in that regard. Let this matter be listed after 4 weeks. I,
Let 50%.
this interlocutory application has been filed. No, you heard Mr. R. Goswami, learned counsel for the petitioner applicant, as well as Mr. Same now, appearing for learned counsel for respondent number 1, 3, 4, and 5, who are the claimants. Stop. This interlocutory application has been filed by the applicant insurance company under Order 41 Rule 5 of the Code of Civil Procedure, 1908, praying for stay of execution of the impugned judgment and award dated 2/5/2024 passed by learned member, Motor Accident Claims Tribunal, Sirang, in MAC case number 6/2023. Stop. The applicant have filed the connected MAC appeal number 456/2024, impugning the aforesaid judgment and award Stop. As the claimants have appeared to their engaged counsel, the notice to other respondents is waived. Considering the submissions 85, considering the submissions, by the impugn order, the Motor Accident Claims Tribunal Sirang has awarded a compensation to the amount, to the tune of rupees 85 lakhs 35,084 only. Stop. To respondent number 1 to 5. Stop. The learned counsel for the respondent has submitted that respondent number 2 has, in the meanwhile, passed away. Stop. Considering the submissions made by learned counsel for the parties as well as considering the averments made in the application filed by the insurance company under order 41 rule 5, this interlocutory application is allowed subject to deposit of 50% of the amount awarded by the impugn order, to the registry of this case within a period of 6. How much time?
6 weeks.
6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
So this, he'll take instructions whether there are any surviving legal heirs of the deceased, whether the mother of the deceased.
And
It can be fixed for a date for order. If there are no other, then they need not take. step.
in main case of learned counsel for the respondent has submitted that he will inform on the next date fix regarding any surviving legal heirs of the respondent number 2 who is reported to have expired.
Obliged.
Oh. Yes, what is this?
Civil appeal petition, my lord. I have come against the order of dismissal of my 711 application.
Who is for the respondent?
They have appeared twice.
Why it has come up in orders column?
Yes, this should actually have come for hearing.
Admission hearing.
Yes,
We'll fix a date for admission hearing.
absolutely, because this is a 2016 matter and it has not even reached the stage of framing of issues.
Okay, we are fixing a date for admission hearing. Heard Mr.
Atanu Saikia.
Atanu Saikia, learned counsel for the petitioner. Stop. None has appeared for the respondents, though name of 2 counsels have been shown in the cause list as engaged counsel for respondent number 1, 2, and 3. Stop.
And they have appeared on, they have already appeared twice.
Yes. Let this case be listed for admission hearing. When should
27th of October,
27th of October,
28th to 8.
28th of October.
Yes, admission, deeply obliged.
Item 44.
May please, your lordship. This is a regular first appeal, lordship. It is filed with a delay of 65 days, lordship. Notice already issued, lordship. They appeared, lordship. And on last occasion on 7/6/2024, they are granted 2 weeks time to file reply, lordship, but no reply has been filed, lordship. Only 65 days delay, lordship.
Then my objection may be recorded, matter may be come on admission, lordship.
The delay may be condoned.
Condone, but my objection only recorded in order.
By showing the objection, delay may be condoned. Okay. Third, Ms. P. Bhattacharya, learned counsel for the applicant. Also heard Ms. What is your name?
A Begum.
A. Begum, appearing for the sole opposite party. Stop. Though earlier time was afforded to the opposite party for filing written objection, however, no written objection has been filed. Stop. This application under Section 5 of the Limitation Act, 1963, has been filed by the applicants for condoning
My lord, with all the respect, my lord, this matter is, my lord, regarding specific relief act, my lord. My lord, agreement for sale, my lord. So I am not objecting, my lord, against the condonation, my lord. Only I am, my humble prayer before your lordship is that, my lord, matter may be fixed for, my lord, after vacation for hearing, my lord.
No, it has to come for admission.
Admission, lordship, not
Yes,
yet
my lord.
numbered.
Oh, sorry, my lord, it is yet not numbered, my lord.
Number, so let us come
Yes.
for admission first, lordship.
But you are not objecting.
My lord, my objection may be recorded, my lord.
You are also,
That, my lord, only for the
no,
respondent.
if you can condone also, you can concede also.
I may not concede because a private matter, my lord.
Okay. Yeah, yeah, लिखा है मैंने। For condoning the delay of 65 days in preferring the appeal, connected appeal by the applicants, impugning the, which is the impugn, what? Impugning the judgment and decree dated 1/8/2023 passed by learned Civil Judge Senior Division Hailakandi in which case?
Title suit number 7 of 2021.
In title suit number 7 of 2021. Why the delay has been, where?
Para 5 and 6 I have explained, lordship. This, applicant number 1 is a lady of 78 years, lordship, and applicant number 2 is her daughter-in-law. 3 and 4 are minor daughter, lordship.
Learned counsel for the applicants has submitted that the applicant number 1 is a aged lady of 78 years of age and is totally bedridden and unable to move. Stop. Without the assistance of others. Without the assistance of others. Stop. She has also submitted that applicant number 2 is a widow.
She is the daughter-in-law of petition applicant number 1.
Who is the daughter-in-law of applicant number 1 and other applicants. How many applicants are there?
4, lordship.
Other 2 applicants are minor daughters. Minor daughters?
Yes, lordship.
Minor daughters of applicant number 2. And stop. Learned counsel for the petition applicants have also submitted that the applicants have explained the cause for delay in preferring the connected appeal in paragraph number 6 and 7 of the application for condonation of delay. Stop. Learned counsel for the respondents has objected to the condoning of the delay in preferring the connected first appeal. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record, including materials on record. Stop. On consideration on this of the submissions made by learned counsel for the parties, as well as on perusal of the grounds mentioned in paragraph number 5 and 6 of the condonation of delay application, of the application for condonation of delay filed by the applicants. This court is of considered opinion that the 6 and 7 of the law considered opinion that the applicants have sufficiently the applicant have explained the cause for delay in preferring the connected appeal, and the said cause may be regarded as sufficient cause for condoning the delay. Hence, this interlocutory application is allowed, and the delay of 65 days in preferring the connected appeal is hereby condoned. The registry is directed to register the connected appeal and list it for admission when
After vacation, any date, Lordship.
after puja vacation on a date to be fixed by registry. This interlocutory application is accordingly disposed of.
Obliged.
Item 45.
Obliged.
May it please your lordship. My lord, this interlocutory application filed for my lord, substitution of legal heir, my lord, who died, my lord. My lord, notices were issued in the earlier occasion, my lord. My friend is, my lord, appearing for the, my lord, original petitioner, my lord. Now, my lord, he is appearing in this matter, my lord. He has told me that he will appear, my lord, for the newly, my lord, implemented respondents, my lord.
All respond.
Yes, sir. Yes, my lord.
Now, why this, there is a condonation of delay application.
My lord.
Substitution application.
Abatement, my lord.
Setting aside abatement. When he died,
My lord, long date, my lord.
then you have
My
to,
lord, yes, my
there
lord.
is a delay of,
616 days, my lord.
then there is a delay in filing setting aside abatement application also. One more application is required.
My lord, then I will file.
Condoning the delay in setting aside abatement.
My lord.
Learned heard Mr. G. Goswami,
My lord.
learned counsel for the learned standing counsel railway department, appearing for the applicant. Also heard Mr.
That's right.
S. Roy, appearing for the respondents. Learned counsel for the applicant has submitted that there is a delay in preferring the application by the applicant for setting aside abatement on the death of the, who died?
My lord, Subhas Das, my lord, sole respondent.
On the death of the original respondent. And for condoning the delay, the applicant may have to file an application. And for the same, he prays for some time. The prayer is allowed. Let this case be listed after puja vacation. The applicant may take necessary steps in that regard before that time. List accordingly.
Date may be fixed, your lordship, it's all in the name.
Let this case be listed again on 4th of November.
Deeply obliged.
1947.
May please, your lordship. This interrogative application is, my lord, for condonation of delay of 7 days, my lord. Service has already been completed, my lord.
I'm for respondent number 1.
You are opposing or conceding?
My lord,
There is a delay of 7 days.
I have no objection. My lord.
No objection. Heard. Mr.
R.
R.
Sharma.
R. Sharma, learned counsel for the applicant. Also heard Mr.
M. Hussain, my
M. Hussain appearing for the respondent side.
lord. Respondent number 1, my lord.
Respondent number 1. As regards other respondents,
Service complete, my lord. Provisional dated 13/9/24, my lord.
as regards other respondents are concerned, on perusal of the notice or on perusal of the office note dated 13/9/2024, it appears that notices issued to the other respondents are duly served. Stop. This application under section 5 of the Limitation Act, 1963 has been filed by the applicant for applicants for condoning the applicant is sole applicant. no?
Sole.
For applicant by the applicant for condoning the delay of 7 days in preferring the connected regular second appeal, whereby the applicant has impugned the judgment dated 28/11/2023 as well as decree dated 1/12/2023 passed by learned civil judge Borpeta in the title appeal number 1/2022. Where you have explained the delay,
My lord, paragraph number 3 and 4, my lord.
the applicant has explained the cause of delay in paragraph number 3 and 4 of the application for condonation of delay. Learned counsel for the respondent number 1 has not objected to the prayer made by the applicant. Stop. Considering the grounds shown for delay as well as the submissions made by learned counsel for both the sides, this court is of considered opinion that the applicant has sufficiently explained the cause of delay in preferring delay of 7 days in preferring the connected appeal, and therefore the said delay is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected regular second appeal and list the same for admission after puja vacation on a date to be fixed by registry.
Most obliged.
Obliged.
1948.
Made to the lordship. Then this is an application for condonation of delay in filing substitution petition, lordship. The appellant, sole appellant, lordship. There is a delay of 341 days. Service is complete, lordship. There is report, it is like X.
3418. Abatement, substitution, or like that. Stay. When he died,
Lordship, it is 6/10/2014.
6/10/2014.
A long delay, lordship, but the case was listed on 28/6/2023 for hearing.
It was earlier admitted and matter was ready. So when the matter was listed, then there was some discussion with the applicant's son, and then the council come to know that the applicant died.
Then you have to make an application for condoning the delay in preferring the application for setting aside abatement. Because abatement application has been filed on 31 May 2024, 10 years delay. So that delay has to be condoned.
I mean, even sometime I shall file it.
Okay.
And this application perhaps will be taken up after that, this conversation petition for filing the substitution petition.
That will be taken
Taken up
after condoning. Heard Mr. R. Sharma, learned counsel for the applicant, who prays for some time for filing an application for condoning the delay in filing the application for setting aside abatement on the death of the sole appellant. The prayer is allowed. Let this case be listed after Puja vacation on a date to be fixed by registry. In the meanwhile, the applicant may take necessary steps.
I'm extremely sorry, madam. The previous matter, item number 40, there is a stay. So stay has to continue. I forgot to mention that.
Item number
40. Yeah.
Interim order shall continue till next day.
My lord, I am appearing for the sole respondent.
But the appellant side is not there.
My lord, in the previous occasion, the adjournment was sought on the ground of personal
No,
difficulty, and
there
the
is-
date was fixed today by the appellant itself.
Interlocutory order. Interlocutory order.
Yes, my lord.
There is no order.
My lord, there was a previous order.
There is no order. You go through it. You have to make your submissions after verifying from the records. Which previous order you are referring to?
Lordship.
Because no order is there.
Yes, Lordship,
Today-
there is an order. Lordship may kindly look upon. Order dated 8 August 2024,
Passed in
passed in IS Civil 1908 of 2024.
1908, so. Who are the parties?
My lord, Union of India versus and General Manager versus Mathan Alloys.
Methanalyze. We don't have that file.
My lord, the order has been uploaded on the website itself.
Okay, but that file is not there.
My lord, matter may kindly be fixed at 2 p.m. I will inform the learned counsel, Mr. K. Gogoi. Because my lord,
No,
the
we don't have files.
file.
The case record is missing. The case record which you are referring to. 1089.
1908.
1908.
Okay.
Eto Putul, verify karo.
My lord, I checked the file in the morning.
We'll fix at 2.
Much obliged.
Eto check karo.
I checked the file in the morning. Madam.
Okay, we'll.
This IA lawsuit to increase the personal lawsuit, the ONGC.
This is a land acquisition appeal.
Lordship. During the land acquisition proceeding, Lordship, this, although the ONGC was the beneficiary of the land, they were not made party. So accordingly, Lordship, appeal was also filed in the same way, without making the party as ONGC as exponent. Subsequently, Lordship, it has detected
Now,
that
whether in appeal can you make them a party?
Lordship, the honorable court on the last occasion has directed us to make a party.
Where?
In order, probably it is not
In
reflected
which
that
case?
the main appeal, Lordship, 8 and 9. So in orders, Lordship, it is reflected or not sure, but
No, whether notice will go.
Lordship may issue notice and same order, Lordship, the respondent, the ONGC has also selects. According to us, the compensation has been already paid lesser than the region amount, and they have selected the award is high and the.
They have challenged, you have not made ONGC a party.
Yes, Lordship, because in
So
the,
ONGC, where they have challenged?
that is why, that plea we have taken in their appeal, Lordship, just since they were not party in past original proceeding, so they cannot be implemented as party in the appeal. That initially, Lordship, that plea was taken by us. Now, Lordship, it has been detected that since that they are the beneficiary, the money will come from them only. So, Lordship, they are necessary party. The court has
So
also.
we are issuing notice.
Lordship.
Heard Mr. J. Kolita, learned counsel for the applicant. Also heard Mr. T. R. Gogoi.
Lordship.
No, in this
Respondent number
respondent number one,
Lordship.
appearing for respondent number one. This application under order 1, rule 10, begin bracket 2 of the Code of Civil Procedure, 1908, has been filed by the petitioner Polorban T Limited. T estate or T limit? Polorban T Limited. Praying for adding respondent number, adding the Oil and Natural Gas Corporation Limited as respondent number 2 in the connected LA appeal number 8/2022. Stop. Issue notice to the respondents since Mr. T. R. Gogoi, learned government advocate, has appeared for respondent number 1. No formal notice need to be issued to the respondent number 1. As regards respondent number 2 is concerned, the applicant shall take steps for issuance of notice to the respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Same in item number 9, item number 53 also.
Next item is
53 also. Only LA appeal number, it will be 9. Instead of 8, it will be 9.
otherwise order will
Yes, all the same. Order is also same.
in item, next item also same order.
Lordship.
Yes.
Deeply obliged.
এটা matter call করে দেব।
Please, Your Lordship. Proceed, this application is for allowing to adduce additional evidence. Notice may be issued.
In the appeal, whether respondent has appeared,
No. Expert. Service is completed, paper publication is done, but not.
additional evidence in in the appellate court, no? Heard Miss, what is your name? P. Hujuri, learned counsel for the applicant / appellant. Also, this application under order 41 rule 27 of the Code of Civil Procedure, 1908 has been filed by the applicant for allowing the applicant to adduce additional evidence to bring on record the extract of GDE number 71/571 dated 5/10/2023 and related documents on records. Issue notice to the, who are the opposite parties?
Claimant and driver, owner.
Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon opposite parties by registered post with AD will, as well as by usual note within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Public.
Third matter in court number 2.
My lord, in this matter, the question of law is covered, and already there has been an adjournment sought, and the date was fixed by the appellant. The matter can be disposed of today itself.
No, but the council is not there.
My
What
lord,
is
we
the,
kept a short date in the. I
Application
don't have any objection. that the
when,
adjournment-
when should we fix? What is the matter?
In regard to condonation of delay, railway claims, my lord, already honorable court has heard the matter in length in the previous occasion. Whether section 5 of Limitation Act is applicable when an appeal is filed.
We have not heard. Heard, Mr. What is your name?
I'm S. Das on behalf of
S.
K.
Das,
Gogoi.
submitting on behalf of Mr. K. Gogoi. Also at Mr. D. Rathi, learned counsel for the respondents. Learned counsel for the applicant has submitted that the conducting counsel, Mr. K. Gogoi,
Respondent.
learned counsel for the applicant,
Respondent.
No, it is
who has filed this condonation delay application.
They have filed.
applicant.
So they are the
Legal-
applicant. Learned counsel for the applicant has submitted that the conducting counsel, Mr. K. Gogoi, is on legs in some other court, and on that ground an adjournment has been prayed. The prayer is allowed. When to fix?
But immediately after vacation if possible.
My lord, before vacation in the matter, because the question of law has been heard, court has already.
Because on the next week, my lord, is a motion day and I think it will take a time. My lord.
Let this matter be listed on 24th of October. 24th October. What is the urgency?
My lord, there is no urgency, it's just.
Then there is, if there is no urgency, let it be on 24th.
Much of it.
Much of it.
59 and 60.
In my okay, who is on legs? Okay. We have to wait. Let him,
No option, no.
huh?
No option, no.
No option. Or should we adjourn it?
No. We'll wait for him.
Okay.
Item 55.
You serve a copy?
Lordship.
Then when should we fix it?
After vacation, Lordship.
Heard, Mr. You also verify whether abatement is the setting aside of a abatement application is within time or not. If
We have
it
filed one condonation of delay also.
for setting aside of abatement.
Abatement, Lordship.
Okay. Heard, Mr.
A Singh,
A.
Lordship.
Singh, learned counsel for the applicant. Also heard Miss M. Sahu, learned counsel for the opposite party, who submits that they have not been provided with copy of applications filed by the applicants. The counsel for the applicant undertakes to provide copies of the applications filed by the application to the within 2 days.
Lordship, some time may be given, Lordship, because the
Within a week from the date of this order. List this matter after vacation on a date to be fixed by registry.
obliged, Lordship.
Item 9.
Yes.
Lordship, we want to get some instruction, Lordship. So Lordship, we need some time. May Lordship grant some time us.
Heard, Miss, what is your name?
B Ronghang P.
B.
Ronghang P.
Ronghang P. Learned counsel for the petitioner, who submits that the council needs some instructions from the petitioner before arguing this case, and therefore prays for an adjournment on that ground. The prayer is allowed. Let this matter be listed after puja vacation.
Item 10 and 11.
My lord, in a commercial suit, my lord, summons were issued and defendant number 1 and 6 were served on 27/4/22. Then on 11/5, my lord, on the date, my lord, so for other defendants are concerned, service was just complete. Defendant number 1 and 6 was ex parte.
No, in this CRP.
Yes. Now, my lord, you will also find they filed several dates elapsed, my lord. They did not come. Then ultimately, my lord, after a long delay, they filed this petition on 28th day of December 22.
Which petition?
A petition for setting aside ex parte order, order 9 rule 7.
The defendant have filed.
Yes. 1 to 6. 1 and 6. That petition you will also find at page 39.
No, whether the other side, respondent side, is not appearing in this case.
Names must be shown, my lord.
This is the item number
For this person,
10 and 11. Names are shown. Mr. S.K. Deori.
Service is complete, my lord.
Only 2 respondents are there.
Yes, yes. 2 responses. Now,
what is to be done?
Now,
we have to proceed ex parte.
My lord, after all, that has to be done because in the trial court also, my lord, on the date that did not appear. Thereafter several dates elapsed. Subsequently, in December, my lord, they have filed this petition.
So we will fix ex parte and fix the date for hearing. There is already an interim.
Yes, my
in
lord.
your favor.
And secondly, second case, my lord, another aspect of matter, WS has been accepted, my lord. In commercial suit, your lordship knows that outer limit is 120 days. After 120 days, there is no chance of filing WS. And Supreme Court has also that, my lord. But here, my lord, what happened? It has been accepted after about 9 months. Second case.
No, first case,
First case, ex parte order, setting aside ex parte order. Here, my lord, under order 9 rule 7, they have to show that.
okay, no, we are fixing it for ex parte. Heard Mr. G. N. Sahewala, learned senior counsel assisted by Ms. T.J. Sahewala, learned counsel for the petitioner. It appears from record, none has appeared for the respondent side. Appears from record that though the names of 3 counsels are shown in the cause list as engaged counsel for respondent number 1 and 2, however, none has appeared. Stop. Therefore, let this case be listed for
Admission.
no, we will admit it and fix it for ex parte hearing. We'll admit the
Not necessarily, my lord, the admission itself, I was can dispose of it. Again, it will be, go to
we
hearing.
fix it for
If they does not appear next date, my lord, your losses can dispose of it. That order will be passed.
for admission hearing. On a date to be fixed by registry after Puja vacation.
And that will fix, my lord, because the suit is pending, my lord, time commercial suit. Your losses may fix a date, my lord, in October.
Suggest
23rd of October or
29th.
29th.
29th October. In the second case,
Same order.
here also the appearance is
No, yes. I think.
same order. Because here also, instead of 2 names, there's names of 2 counsels are shown in the cause list as engaged counsel for. Let this case be fixed for admission hearing on 29th of October. None has appeared for appellant on call. Let this matter be listed in the next week on a date to be fixed by registry. Yes.
My lord, in this present matter, an appeal has been filed challenging the order passed by the Railway Claims Tribunal bearing order dated 29th May 2024 in original application 21/2017. My lord, initially the claim was preferred before the Railway Claims Tribunal for rupees 3,63,685 on account of freight collected for excessive distance and at excessive rate, and rupees 16,68,244 on account of illegal collection of penal charges on allegation of overloading. My lord, Honorable Railway Claims Tribunal has allowed our claim to the tune of rupees 16 lakhs for the penal freight which was collected, and we are preferring an appeal for the remaining amount, my lord, for the amount which was excessively collected.
Okay. Heard. Mr. R. Mr. R. Rathi.
D. Rathi.
D. Rathi. Learned counsel for the appellant. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been preferred by the appellant, impugning the judgment and order dated 29/5/2024, passed in original application number OA within OA Roman 3-21/2017, passed by Railway Claims Tribunal, Guwahati Bench. Issue notice to the respondents. You have notified the Standing Council Railway Department.
Yes, my lord. My lord may call for lower court records.
The petitioner shall, the appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let the records of original application number OA 3-21/2017 within bracket old be requisitioned from the Railway Claims Tribunal, Guwahati Bench. Let this matter be listed after 4 weeks.
My lord, any date may be fixed.
No date.
Huh?
No date after 4 weeks. 4 weeks on a date to be fixed by registry.
Much obliged.
None has appeared for the appellant on call. Let this matter be listed in the next week on a date to be fixed by registry.
Lordship, this is an appeal for enhancement of compensation, Lordship.
Heard Mr.
M. Talukdar.
M. Talukdar, learned counsel for the appellant. This appeal under section 173 of the MV Act has been preferred by the appellants / claimants praying for enhancement of the amount of compensation awarded to the appellant / claimant by the impugned judgment and order dated 9/4/2024, passed by learned member, Motor Accident Claims Tribunal, Morigaon in MSC case number, MSC within bracket death case number 32/2020. This appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let the case record of MSC within bracket death case number 32/2020 be called for from the concerned tribunal. List accordingly.
Obliged.
None has appeared for appellant on call. Let this case be listed in the next week on a date to be fixed by registry.
Item 62 from supplementary.
So in this case, the plaintiff issued a civil suit against the defendant for declaration of right, title, and interest. And so far the decree is concerned, decree with respect to the schedule land B and C was granted. But so far the schedule land D is concerned, that was not granted. Against that decree, we preferred an appeal. And in the
You were the plaintiff.
I'm the defendant.
You were the defendant.
Defendant. So far the decree is concerned, 3 lands B, C, and D.
B is degree granted, C degree granted, D is not granted. We preferred an appeal before the senior division bench, and our contention was that the land in question, I have found a substantial question of law, my lord. Our contention was that the land was a annual patta land, and this annual patta land was purchased, and subsequently the annual patta land was converted to the periodic patta in favor of the annual patta land holder who expired, my lord. And based on that patta, thereafter the periodic patta was granted in favor of the plaintiff. That is one aspect of this case. Second aspect of this case is that
Yes.
second aspect of the case is that the plaintiff's case is that they issued a notice on 25/1/2005, and in that notice they have stated that we that we were called upon to vacate our land in the year 73-74. The suit was instituted in the year 2006. On that count also, the suit is barred by limitation. However, they have stated that another notice was issued to the defendant where it is stated that we have enclosed the land in the year 1995. Be that as it may, my lord, so far the notice is concerned, that was not proved by the plaintiff himself and the lawyer himself, the plaintiff. The lawyer who issued the notice, he was not examined. The plaintiff who issued the notice, he was not examined, but he, before examination, he died, my lord, and in his place, his wife and son was substituted. Now, son was there, my lord. But so far the notice is concerned, that notice was not examined, proved by the lawyer concerned. These are the 3 points, and apart from that, there is a question of adverse position in favor of the defendant.
No, regarding notice, this plea was taken by you before the first appellate court.
The first appellate court discuss this matter, my lord.
Then, because this is a question of fact, notice. So whether this can be gone into in second appeal.
No, whether this suit is barred by limitation or not. Because undoubtedly, if the suit, if I was called upon to vacate the land in the year 1974 or
But
78.
that was a question of fact, whether notice was given or not. For deciding upon a question of fact, the trial court and the first appellate court are the proper court.
Yes, that is true. But so far this factual aspect is concerned, there is a perversity.
Perversity is there.
Yes, perversity is there. I can demonstrate it.
In not considering the plea of adverse possession.
I am considering the plea of adverse possession also. One নোটটা কোথায় আছে? নোটটা আর ও কোথায় গেল আবার পাঠ করে? আচ্ছা। So far perversity is concerned.
Yes.
Your Lordship may come to page 73 of the plaint. The plaintiff, page 8, no? The plaintiff number 1 claimed only such and such land, purchased 1 bigger, a copy. Yes. The plaintiff number 1 claimed only 10 bigger, 2 gutters, 10 lessers of land. Got it, Lordship?
Yes.
Plaintiff purchased 1 bigger of land under the number such and such annual patta through an unregistered kacha deed, which is inadmissible in the evidence as earlier. Now, my lord, here, exhibit paragraph 17, sorry, so far paragraph 16 is concerned, my lord. Paragraph 16, that on 24/1/2005, the plaintiff number 1 served a lawyer's notice upon the defendant number 1, whereby he withdrew the permission which was accorded earlier in the year 1973 to deliver the suit land, scheduled land of the plaintiff, and also deliver the possession of the said land, which the defendant trespassed about 4 bighas of land within 1 month. That is in the year, within 1 month and in the year 73. Within 1 month from the date of receipt of this notice. The defendant number 1 received this notice on 2/2/2005, but did not comply with the request therein. Though the plaintiff number 1 claimed 10 bigha 2 kata 10 lesser of land, since the plaintiff number 1 purchased 1 bigha of the land under such and such dag number FP Pata through an unregistered kacha deed, which is inadmissible in the evidence as stated in above. Now, in the next paragraph, that there was a typographical mistake in respect of the year and Saka, by which the defendant number 1 trespassed upon the land of the Schedule B. Hence, the plaintiff number 1 served a registered letter through his advocate dated 28/7/2005 upon the defendant number 1, whereby the plaintiff corrected the typographical mistake as under the second page of para 2, line number 2, Shaka 1897 AD, 1974-75 was corrected as Shaka number 1994-95. Again, the line, that is, initially he stated that he was called upon to vacate the land 1974-75. Subsequently, again, another notice says that there was a mistake. In fact, he was called upon to vacate the land in the year 94-95. Be that as its name, Lord. In the impugn judgment, Lord, withdrawal of the permission, page 16.
Yes.
Here. Page 16, para 5. Para 5, para 5. Para 5. Page 16, done. Page 16 is the middle portion. The defendant number began to reside on 24/1/2005. We got it.
Where, which line?
About middle portion, para 16.
Page 16.
Sorry, page 16. On 24/1/2005, got it?
On 24/1, the predecessor of the plaintiff.
Plaintiff served a notice to the defendant number through his lawyer, whereby he withdrew the permission which was accorded to the defendant number 1 earlier in the year 1973 and asked the defendant number to deliver the corporation.
Yes.
So, here it is clear, Lord.
What it implies?
That on 24/1, the petitioner plaintiff served a notice to the defendant number 1 through his lawyer, whereby he withdrew the permission which was accorded to the defendant earlier in the year 1973 and asked the defendant number 1 to deliver the suit land schedule, the predecessor of the plaintiff, and also delivered the first position in the entire suit land to the predecessor plaintiff. Even after receiving that notice, defendant number 1 did not comply with the request of the predecessor, the plaintiff having no other, it is much clear, my lord, in the year 1973-74. Actually.
Now, what is your contention?
By this notice dated 200, it was stated that the defendant number one passed the trespassed the suit land in the year 1973-74.
Yes.
In the year 73, and that suit was instituted in the year 2006.
But they are saying that in 2005 we have given a notice. So the computation will start from 2005. That is perhaps their plea.
No, actually their contention is there. Yes.
That
Yes,
that we
yes,
have
that is their
issued-
contention. But in the plain they have said something else. That just now I have found it out. In the plain, just now I have said it. Paragraph
7,
Huh?
page 73.
Page 73. That on 24/1/2000, a plaintiff number served a lawyer's notice upon the defendant whereby he withdrew the permission which was accorded in the year 1973 and delivered the suit petition D. And also delivered the first position of the land which defendant number about
Same thing.
same thing, Lord. So, Lord, if this is the same thing, Lord, then what happened? He was called upon to vacate this land in the year 1973, and he instituted the suit in the year 2005.
But he's saying that plaintiff number one, through his lawyer, gave a notice for eviction of to vacate the suit land in 2005 also. In 2005 also. Therefore, perhaps their plea is that the limitation will start from 2005.
No, because it will be fortified if you also go through paragraph 17.
Of the plaint.
Of the plaint, paragraph 17.
Yes.
There was a typographical mistake in respect of the year and shaka of the defendant number one trespassed upon the land of the schedule B. Hence, the plaintiff number one shall be registered letter to his advocate on 28/7/05. That is exhibit 10. And the earlier one is exhibit 9. Upon the defendant number one, whereby the plaintiff corrected the typographical mistake. In page 2, paragraph 2, line 2, Soka 1980-74 was corrected as 1994-95. So it is evident that they were called upon to vacate the land. Initially, they told that you should vacate the land 1973-74. Thereafter, he has rectified to say, no, it is 94-95.
Okay. Thereafter, what happened?
Initially,
Initially, in the plaint, they have stated that the plaintiff gave notice to defendant number one in 2005, stating that they were asked to vacate the land in 1974-75. Later on, they filed another, rectified it, and said that it is not 74-75,
it should be
it is 94-95.
95, then the limitation is there. Because
90
suit was issued in 2006.
Okay, 94-95.
If it is 94-95, then this is just few days earlier than that.
Yes. Now, what
that
is
apart below, this notice was not put by the lawyer or even by the plaintiff number one who expired.
who proved the notice?
The plaintiff number two. Plaintiff is the wife of plaintiff number. Plaintiff not two, to 1A person.
No, but that is a question to be dealt with by the first appellate court. This question could have been raised before first appellate court.
First appellate court was raised.
What it decided. Now, here the question is where the first appellate court erred in law what is the substantial question of law? We have to formulate the,
So for subsection question of formulate law, well, you can formulate point number 1. Whether the execution of sale deed with respect to an annual pata land confers the right title interest in favor of the purchaser of the land. Number 2, if the sale deed with respect to the annual pata land does not confer any right title interest, the revenue record in favor of the purchaser of the annual pata land shall confer any right title or interest.
in this case, the respondents are not, oh no, notice has not yet gone.
But yes, respondent appeared in the condonation petition, Judge.
Okay.
And it was condoned. Or one thing that can be done, Your Lordship, we can only stay the execution of the decree and let them come. And
No,
contest.
no, but before that, what is the substantial question of law?
One may be
In
considered.
whose possession land is now? In your possession?
Yes. it is.
Since when it is in your possession? Since when it is in your possession?
Since 1971.
74.
71 onwards. Plenty was my brother, elder brother.
Now you suggest the substantial question of law.
One may be from frame 1 and 2, and if Your Lordship have some not inclined to 3 and 4 later for the timing. And third one is whether the defendant has the adverse position with regard to the suit land or not.
And
Here only thing.
issue regarding adverse possession was framed.
Yes. Not in that.
Where is that issue?
Conversion. Page 45. Issue number 15. Long possession. Page 45. Whether the long-standing possession of the defendant number 1 and his family member, have you got it?
Yes.
Over the suit land, given him a right to possess the suit land permanently, and whether the defendant were trespasser.
What was decided again?
This is at page 55, below. Issue number 15.
You were held to be a permissive possessor. The earlier notice was given in the year?
In the year 2005.
Before that?
I was in possession. No, in that 2005 notice, they have stated that you were called upon to vacate the land in the year 73, 74.
So from
Subsequently, they rectified
73,
it.
from 73, 74, the land would not be a permissive possessor. Because if you are called upon to vacate from 73, 74, it becomes an adverse possession.
Yes.
Is it or is it not?
Yes, it is.
Because the finding of the trial court is that you are a permissive possessor.
I was called upon to vacate this land.
Once you are called upon to vacate the land, and thereafter if you continue the possession, whether the possession would be permissive or adverse.
Licensee or trespasser.
Or trespasser. Or if you... So what would be the issue regarding... Okay.
whether the defendant acquired the defendant adverse position may only be considered, that one thing. And 1 and 2 may be considered. And if your lordship is on the view that this is a question of fact, later on it may be argued.
Okay, heard. Mr. A. Das Gupta, learned senior counsel for the appellant, assisted by Miss B. Das, learned counsel for the appellant. This second appeal has been preferred by the appellants. Namely Raju Hazarika, number 2 Srimati Jonaki Hazarika, number 3 Srimati Ritu Hazarika, and number 4 Srimati Ranu Hazarika, impugning the judgment and decree dated 30/5/2023, passed by the Court of Learned Civil Judge Golaghat in title appeal number 5/2017, whereby the first appellate court had upheld the judgment and decree dated 9/6/2017, passed by Learned Munsif number 1 Golaghat in connection with title suit number 13/2015. Decreeing the suit of the respondent. Suit was for declaration of right title
Interest.
and recovery of
First position.
for
So far, first position is concerned, it is in my favor so far Schedule and D is concerned.
decreeing this to stop. After considering the submissions made by Learned senior counsel for the appellant, and after going through the memo of appeal and the annexures annexed therewith, following substantial question of law are formulated in this appeal. What is the second substantial question of law?
If the cell deed, so far, first is whether I give cell deed. I gave it to you as a fresh.
Yes.
If the cell deed with respect to the annual purchase does not confer any right title interest, the revenue record in favor of the purchaser on annual purchase whether confer any right title and interest. The revenue record purchase does not confer any right title and interest.
Number 1, whether the execution of sale deed in respect of an annual patta land confers any right title and interest in favor of the purchaser of the said land, comma, if not, whether the incorporation of names of the purchaser in the revenue records
We confer any right.
in respect of an annual patta land confers any right title and interest to such purchaser in respect of the said annual patta land. Stop. Inverted comma close. Next, number 2. Whether the finding of the first appellate court 45, page 45 is the trial court or first appellate court? Trial court.
What is the trial court issue frame?
Whether the finding of the first appellate court. What first appellate court held in against issue number 15? What it said?
Nothing has been stated. Sir.
It has not discussed.
Just a minute, let me check it up. Nothing has been stated. No.
Whether the trial court was whether the finding arrived at by the trial court in respect of issue number 15 framed by it, holding the defendant number 1 to be a permissive possessor, is a perverse finding which was upheld by the first appellate court. Bracket close. Abhishek, read call. Please listen to it.
Any other issues that may be framed by the court?
जोर से पढ़ो.
आवाज.
You listen to loudly. No. Face issue occurs. And the council should hear it. Issue number 15 arrived by it. The second formula question is whether the finding arrived at by the trial court in holding defendant number 1 to be a permissive possessor is a perverse finding, and whether the first appellate court was wrong in upholding that perverse finding. This is the second issue.
Much of that.
The appeal is admitted. Let the notice be issued to the respondent. Only one respondent. Who is this Ripu Hajarika? Is he your relatives?
Yes, it is my his cousin.
The appellant shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly. What is this IA for?
For stay of the decree.
Whether execution case has been filed?
Yes.
They have filed an execution.
They have filed an execution, but
what is the execution case number?
Number of course I don't know.
Heard Mr. A. Das Gupta, learned senior counsel, assisted by Miss B. Das, learned counsel for the applicant. This interlocutory application has been filed by the applicant under Order 41, Rule 5 of the Code of Civil Procedure for stay of execution of the judgment and decree dated 30/5/2023, passed by learned Civil Judge Golagad in Title Appeal number 5/2017, which has been impugned by the applicant by preferring the connected regular second appeal number 81/2024. Stop. Issue notice to the respondent. The applicant shall take steps for issuance of notice upon the respondent by registered post with ID as well as by usual mode within 7 days from the date of this order. No, within 2 days from the date of this order. Returnable on 5th of November 2024. However, in the meanwhile, as the connected regular second appeal has been admitted and substantial question of law two substantial question of law have also been formulated therein, till the next returnable date, the execution of the impugned judgment is hereby stayed. Impugned decree is hereby stayed. List accordingly.
Much obliged. Yes, Chandrama.
I would like to say that while order dated 5/9/2024, it was listed after Puja vacation, but when they entering the council had gone and made a mention without mentioning this, that there is an order.
My lord, in the previous.
Let her submit.
Yes,
Let her complete, then you make your submissions. Now, are you ready?
Ready, but the plan from society. The lordship is inclined to take the matter.
No, I will take, if both of you are ready, I am ready. Yes.
My lord, in this matter.
How much time will it take?
My lord, it won't take much time, hardly 5 minutes from my end.
So after 5 minutes, I will stop you.
Yes, my lord. They will not even 5 minutes, my lord. My lord, this.
Then you mind your words. After 5 minutes, I will not allow you.
Only if there is no objection from my learned friend, my lord. My lord, my submission is.
Because my experience is.
Yes, my lord.
If you mention 5 minutes, you will go on for hours. Not you, lawyers.
Yes, ma'am.
So why I was querying this point, because whether you are ready, bail, both parties are ready, NCB is ready. If you are not ready, instead of waiting, you are ready. Okay. No. Then I will fix a date. Therefore, I have asked. Then I will hear this appeal.
Always these things has happened in NCB case before this honorable court only.
No, but if there is a ailment, if
No,
lawyer
no,
is.
he could have informed us these things in the
Ah,
morning.
This.
Right now, little bit earlier, they informed that he is on legs in court number 710. But it is not ethical, lordship. They could have informed in the morning that I have some personal issues, so take a time. That was the better way, lordship. That
No, let us believe.
we believe that thing, lordship. He has personal issues, but we are waiting for him 3-4 times. They are adjourning the matter.
No, she's submitting that all on a sudden he has
No.
left.
He has a issue that his brother undergone operation, lordship, 2 years back.
Okay,
And that is why he
choose a date. When we can take it. Not tomorrow.
No, not on Tuesday. Lordship, it will take again time, then it will be after vacation. Then can it be fixed on Friday, lordship?
Friday. choose a date where I record to sound. Tuesday is okay for you.
I have no option, Lordship, because on Friday they are not available. On Monday also not available.
Let me see the record.
They're inside the jail for about 2.5 years in this matter, and other matter, Lordship, more than 3 years.
Yes, it is. Okay, Tuesday we'll hear. At 2. At 2. Heard Miss S.K. Nargis in all 3 cases.
Yes, Lordship. NCB early.
All-
All 3 cases not out of same FIR, Lordship. 61 and
Same council,
50
same
council, Lordship, same council.
in item number
Item number 59, 60 and 61.
59, 60 and 61, same order. Heard Miss S.K. Nargis, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for the applicant, who submits that the conducting counsel for NCB, Mr. S.C. Kayal, had a sudden medical urgency for which he had to leave the court, and hence prays for an adjournment. Stop. Considering the grounds mentioned by learned counsel for the NCB, the prayer is allowed. Let this case be listed again on Tuesday, kivan tarikh? On 1st of October 2024 at 2 p.m.
Lordship. Already.
It will last. Our case.
Yes, my lord.
Yes, tell me.
My lord,
Yes.
in this present matter, the present appeal was filed on 19th November 2012. My lord, after the filing of
This
the,
appeal is under what provision?
under section 23 of the Railways Act, Railway Claims Tribunal Act.
Okay.
My lord,
Putul Railway Claims Tribunal Act. Yeah. Railway Claims Tribunal. Yes. Yes.
my lord, in this present matter, there was a descending. Initially, a judgment was passed by the Railway Claims Tribunal by the technical member. Later on, in the same date, a judicial member passed a judgment. Both were descending judgment. My lord, later on, the matter was referred to the third member, and third member passed the order. My lord, after the filing of the present appeal, my lord, may kindly come upon page number 38 of the appeal.
Before you make submission, what was the facts? Why the appeal has to be preferred?
My lord.
Brief fact. So, what is your story?
Yes, my lord. My lord, we preferred a claim. Our claim was repudiated by the railway.
Claim for what?
Claim for terminal charges, and my lord, there are various other claim, my lord. Today, my lord, I do not want to go into the merits of the matter. My lord, my only humble submission is the matter should be remanded back to the tribunal, because, my lord, after the filing of the present appeal, there was a very reportable judgment passed by the Honorable Guwahati High Court, which is stating that once a descending judgment passed by both the members of the tribunal, and the matter has been referred to the third member, later on the matter has again to be referred back to the tribunal,
and the division, both the members of the tribunal has to pass a majority judgment based on the judgment passed by the third member, my lord. The same, it was filed, because of which, my lord, my humble submission is the matter be remanded back to the tribunal for fresh adjudication.
When the claims. Okay, no. Tell me the facts. When the judgment was passed by the technical judge.
My lord, may kindly come upon page number 38 of the appeal. Technical member passed the judgment on 7 June 2012.
Seven?
Page number 38, my lord.
Yes,
Judgment dated 7 June 2012.
it is 7th October, 7th August. On 7 June.
7 June, my lord.
What was the judgment?
My lord, in this technical member has allowed our claim. My lord, may kindly come upon page number 5 of the judgment, page number 43 of the appeal. Herein the final conclusion of the judgment has been mentioned. In the last paragraph, the honorable technical member of the RCT has stated, under such circumstances, it will be against the legal tenant and natural justice to levy terminal charges. Thus, the applicant is fully justified in the claim as alleged in their application, and they deserve compensation as per the following calculation. And at page number 6, the operating part of the order has been mentioned, my lord.
Okay, thereafter.
Thereafter, my lord, on the very same date, 7 June 2012, a descending judgment was passed by the honorable judicial member of the honorable RCT. My lord, may kindly come upon page number 56 of the appeal. Page number 46, my lord.
Who was the technical member? What is the name?
Name of the technical member. My lord, T. say Nagle. TCNAGLEY, Nagle.
And judicial member?
And my lord, judicial member, my lord, T. Palik, PALLICK, Palik Appara Ampil. My lord, page number 44. It is written.
What was decided?
Yes, my lord.
What was decided by the?
My lord, at page number 46, if my lord is there.
No. The
dissenting
judicial
judge-
member.
Yes, my lord, judicial member only.
Where is his decision?
At page number 46 of the appeal.
46.
46.
Yes.
At page number 46, man. Herein, in the subheading at bold, my lord, it is mentioned, Honorable Member Judicial Shri Thomas. In brackets, my lord, it is mentioned dissenting. A dissenting order was passed by the Honorable Judicial Member. wherein the honorable judicial member repudiated our claim.
What relief was granted?
My lord, our claim was repudiated.
No,
Relief-
but some relief was granted, it appears from page 47. You read
Page number 37.
47.
40.
You read para 3.2.
Though the package consignment was booked and delivered at a regular goods booking and delivery station known as goods shed managed and controlled by the railways for the last 20 years and never notified as a terminal, and no terminal charges could be levied as the consignment was packed one exempt from terminal charges as per Railway Board Circular so and so. My lord,
Read complete.
unless crane handling was required and in spite of the fact that the circular dated 18 September 2007 is confined to enhancement of the terminal charge, respondent levied terminal charges illegally. In the circumstances, it is entitled to refund terminal charges to along with the overcharges, my lord.
So terminal charges were granted.
How? My lord, in the paragraph 3, in the in the paragraph 3, it is stated that it is the submissions of the applicant. It is not the observation of the court, my lord.
Where?
My lord, at page number 46, para number 3.
Okay, thereafter.
Thereafter, my lord, in the if my lord may kindly look upon.
Why it is along the
May kindly come upon page number, paragraph 12 of the said judgment passed by the judicial member.
Yes.
My lord, here it is mentioned, likewise, I am unable to agree with the view of the learned brother that terminal charges have no jurisdiction because of the reason that no power is conferred on this tribunal to enter on a finding whether terminal charges are justified or not. The power to enter on such a finding is vested on some other body. My lord, may kindly come upon page paragraph 19.1.
Yes.
Here it is stated, my lord, as the applicant has not stated what is the minimum freight payable for 3,000 kilometer. I am of the view that the rebate sought for by the applicant cannot be granted until he states the minimum freight payable. Case for the applicant that he is not liable to pay terminal charges cannot be accepted, my lord. It is a dissenting judgment passed by the honorable judicial member.
Okay, thereafter.
Thereafter, my lord, the matter was referred to the third member. At page number 57, my lord.
Okay.
My lord, may kindly come upon paragraph 15, page number 67, the operating part of the judgment passed by the learned third member, vice chairman of the. Para 15, my lord, the opposite discussion would make it clear that the documents relied upon by the applicant is not sufficient to come up with a positive conclusion that the booking of the terminal station are exempted for levy of terminal charges. Therefore, my findings on the opposite point is a negative, and accordingly, I subscribe to the views expressed by the honorable judicial member in this judgment on the point of terminal charges.
Okay, now what is your submission?
Now, my lord, my submission is as per the judgment, this judgment, the present judgment, in the case of Union of India versus Mahesh Enterprise, my lord, which I just furnished, my lord, this judgment was passed after the filing of this present appeal. And according to this judgment, my lord may kindly come upon page number 3 of the judgment.
Yes.
My lord, here in the second paragraph, it is stating, in my considered opinion, after the opinion has rendered by the third member on 28 June 2013, the matter should have been placed before the division bench for passing a final order on the main claim application in conformity with the opinion expressed by the third member. In other words, depending on the majority view of the 2 members out of the 3 members, a final order was required to be passed by the division bench for the disposal of the claim petition, my lord. My lord, in this present case, a final order has not been passed by the division bench. Only a third member judgment was passed and later on an appeal was filed. Further, my lord, in the next paragraph, it is stated, in fact, once the third member expressed his opinion on the conflict, holding that he has agreed with the member, the division bench has to apply their mind by reading the opinion expressed by the third member and then pass a final order on the claim application. Since the third member expressed his view, the division bench got jurisdiction to pass a final order in conformity with the opinion of the third member. Such order, when passed, becomes a final order appealable by the aggrieved party under Section 23 of the Act. So long as final order is not passed by the division bench after receipt of the opinion of the third member, no party has the right to file an appeal, because till then no legal order comes into existence for the disposal of the claim petition. In continuity, my
So
lord,
then your appeal is premature.
my lord, what happened in this present matter was there was a judgment passed by the technical member. There was a dissenting judgment passed by the judicial member. Later on, the matter was referred to the third member. Third member passed the opinion based on the judgment passed by both the parties. According to this judgment, my lord, the opinion of the third member should be, the matter should again be remanded back to the division bench of the tribunal for a final decision. Because the third member judgment, the judgment passed by the third member shall not be a binding judgment. Reason which we preferred an appeal. Later on, this judgment came in before passed by the Honorable Guwahati High Court. That's why, my lord, my only humble submission is the matter be remanded back to the tribunal, to the division bench, and a fresh adjudication should be done on the basis of the opinion given by the third member, my lord.
No fresh adjudication. Final order only has to.
Based on the opinion passed by the learned third member.
So it will be majority opinion.
Division bench, my lord.
It will be otherwise. Yes. Anything else?
No, my lord.
Sir, Lordship, the facts of the matter are yet are to be discussed in this matter, because here we are objecting to this particular point, because I would like to refer to section 21, upon which the learned RCB had referred the matter to the third member, that is the chairman. of the Lordship.
Yes.
Buildings Tribunal Act, section 21.
Yes.
Lordship, here I would like to read the section. Decision to be by majority. If the members of a bench differ in opinion on any point, they shall state the point or points on which they differ and make a reference to the chairman, who shall either hear the point or points himself, or refer the matter for hearing on such point or points by one or more of the other members, and such point or points shall be decided according to the opinion of the majority of the members
who have heard the case, including those who first heard it.
Okay.
Your Lordship, here, in the appeal, probably in page number 5 of their appeal, Your Lordship, here in paragraph number 3. Here, they have specifically mentioned that the learned tribunal treated ex parte and no written statement was filed by the respondent. The matter was heard by the division bench of learned tribunal. Your Lordship, they themselves, they are accepting the fact that there is a division bench itself. Then the matter.
No, where? In para?
Paragraph 3 of the appeal that they have filed, Your Lordship. Page number 5 of appeal.
Yes,
Paragraph number 3, Your Lordship.
yes.
The learned tribunal proceeded ex parte and no written statement was filed by the respondent. The matter was heard by the division bench of learned tribunal and judgment was reserved on 23/4/2012. So, Your Lordship, the later on, by judgment dated 7/6/2012, both the technical member and the judicial member, they expressed their consent in two different forms. So later on, under section 21, the matter was referred to the third member. And Your Lordship, in the judgment itself, it replies it's a forum. It is mentioned here, it's a forum.
Where at page?
Your Lordship, the judgment dated 14/8/2012, judgment given by the, it is, Your Lordship, that the appeal was submitted, there is no paging done here, Your Lordship, in our copy. So I'm unable to.
Lordship may kindly look at page 57.
Fact of the matter, the interpretation of this particular section has to be dealt with, Your Lordship, because if the reference to this particular forum member is enough that the majority is being described by the dissenting member, it's the dissenting judgment as well as the judgment of this particular vice chairman, they both form a majority, then the judgment given by both the parties are to be taken together. So that is where then the RCT made this decision, but in the case that has been brought before Your Lordship, here in this matter, the subject matter that is referred, that they referred the matter when the matter was referred to the RCT, then again a decision was taken by a bench, division bench. Then again after that, it was it again came to the High Court. Then again it went to Supreme Court. That's a different matter, Your Lordship, this matter, yes. Not regarding this particular subject matter, Your Lordship. I'm not telling, it's a reference of the case, referring to different subject matter. But Your Lordship, here in this matter, Your Lordship, initially I have also made a written statement, Your Lordship.
No, what is your response to his submission that
Yes, Your Lordship.
that after the third member gives a judgment, matter has again to be sent back to the division bench?
It is not, this interpretation of this particular section doesn't say, Your Lordship.
Interpretation say that it has to be on the basis of majority, including the first two who gave the judgment and the third one. So the majority seems to be dismissing the claim of the
Claim of the claimant. Yes.
claimant. But
there is no provision that the matter again has to be referred to the, for another hearing.
My lord,
to that
no,
particular-
hearing is not necessary.
my lord, this present judgment. that
I'll
has
come to
cited-
you, come to you.
Yes, ma'am.
You note down whatever reply you want to make. I'll again come to you. The judgment cited by the appellant's counsel describes a procedure. The judgment describes a procedure which should have been followed.
In this opinion, Your Lordship, they don't even have the right to come before this honorable court, Your Lordship, by way of appeal.
Yes, if we go by
If
that
we go by
that judgment, yes, then this appeal can be dismissed.
Yes, my lord. My lord, in that regard, I would like to submit that the present judgment was passed after the filing of this present appeal. Reason which we preferred this appeal after that this judgment came into the
No,
line.
if you are relying on that judgment,
Yes, my lord.
then that judgment says that the appeal is, then if we go by that judgment which you are relying,
Matters be
that
again
is,
remanded back to the division bench.
no, then this appeal is, yes, appeal is to be dismissed and matter has to be sent back to the division bench.
To the tribunal, to the division bench for
No fresh adjudication.
based on the opinion expressed by the learned third member, my lord.
Where is the final order?
By the third member. My lord, there is no final order.
Let us read 21 once again. 21 is important.
My lord, this judgment is based on section 21. The interpretation of section 21 is made in this judgment only. At page number 2, section 21 is mentioned, and later on the honorable court has interpreted section 21.
Is this judgment has been reported? Whether this judgment has been reported?
Yes, my lord.
Have you searched somewhere?
Hmm.
This is a certificate copy. Now, what is your submission? What should we do?
Of this particular
21.
section. So here the majority judgment what I feel is because there is a forum that is being mentioned. When the vice chairman's judgment, there is forum term is mentioned.
Where?
Judgment itself, page 57.
Where?
At the heading of the before the railway will start.
Page 57.
Judgment in order dated 14/8/2012. Forum Dr. S.Y. Padhe, Honorable Vice Chairman, Railway.
No, that page is not there. Page 57 is here. Page 57 is the
It may be page number 58, Your Lordship. In their appeal is page 58.
58 is Maheshwari and Mr. Bhima. No,
Above that, Your Lordship, where the name of the Honorable Vice Chairman is written, Your Lordship.
S.Y. Padhe. Only one member. What do you want to say?
Lordship, as because this particular section infers that I can draw an inference that, Your Lordship, that the majority is from the technical member. There is a dissenting judgment and one is consenting judgment. Now, dissenting judgment as well as the judgment in favor of the railway, accepting the dissenting judgment. These forms the majority, Your Lordship.
Without there being any necessity of sending the same to the division bench. But the judgment, you read this judgment, have you read this judgment? Which is,
Just brought the copy. I downloaded the copy from the website, Your Lordship, if I unable to. Your Lordship, here, I don't know, maybe I match or not, because, but it is the order dated 25/2/2014. It is there, Your Lordship. 25/2/2014, Your Lordship. So I would like to refer to Your Lordship, in third page number 3 of this judgment.
third page,
Yes.
third paragraph,
Yes.
in my considered opinion.
In fact, on the third member.
No, before that, you read the preceding paragraph.
In my considered opinion, after the opinion was rendered by the third member on such and such day, the matter should have been placed before the division bench for passing a final order on the main claim application in conformity with the opinion expressed by the third member. In other words, depending on the majority view of the two members out of three members, a final order was required to be passed by the division bench for disposal of the claim petition. But your lordship, here in this particular, no mention of division bench is made, your lordship, that the matter has to be referred to the division bench. Because third technical member is a here, your lordship, in this section, I would again like to read it, your lordship.
Yes.
That if the member of the bench differ in the opinion on any point, they shall state the point or points on which they differ and make the reference to the chairman, who shall either hear the point himself or point or points himself. He can hear it himself, or he may refer the case for hearing on such point or points by one or more of the other members. But here he himself have heard it, and such point or point shall be decided according to the opinion of the majority of the members who have heard the case.
Call.
And including those who first heard it. Supposingly, your lordship, it is referred to both the division bench. Again, if there is the two version comes out of this.
No fresh adjudication can be there. What is being meant by the judgment is that, though it is not very clear, that once the third member passes it has to be in favor of either of the, because two views are already there. One is allowing, one is rejecting. The third member's view, once he passes, if he passes an order, it has to be sent back to the division bench. Then, on the basis of three views available, the majority view will prevail. A final order has to be passed on the basis of the majority view. So that order is perhaps missing. So after that majority view is given, that right to appeal accrues.
Yes, lordship.
Now what has happened? First member given view, second member, the reference was made, third member has given view. Now we can, by analogy, we can find out that it is a majority judgment rejecting the claim. But the judgment cited by the appellant side is saying that the procedure should be, after third member gives his view, it should be returned back to the original bench of division bench, which should pass a final order, not fresh adjudication. Pass a final order on the basis of the view given by the third member.
Yes,
So that final order has to be passed.
So in that regard, your lordship, again, the fact comes into the point that now I have this.
It is only a question of formality, matter of formality.
Yes, ma'am.
You have any submission?
As your lordship may please.
The matter, the appeal would be dismissed and the case would be remanded back to pass that final order in person to the judgment of the.
Yes. My lord, in this matter also, honorable court has remanded back to the matter.
Whether his right to appeal, he again comes on appeal or not, that is a different question.
Yeah. My lord, just one small thing, my lord, the claim was in regard to terminal charges, my lord. Honorable Guwahati High Court, in a very recent judgment, has mentioned.
But you are not arguing into merit.
My lord, that time it was not there. I just want to mention that this judgment be considered. This very latest judgment of the Honorable Guwahati High Court be considered. It is only in the, it's only.
No, then we have to go into merit. whether the
Then again, it is
Take-
setting aside all the judgment.
then take
We
it.
have to rely on judgment.
Now we are not setting. What you have already argued, and after hearing the other side,
Yes, my lord.
your point was limited.
Agree,
to-
my lord.
Now, if we want to hear on merit, I am ready. Then we
That
have
will
to
be a
go-
different thing, my lord. The
Then-
merit is not in question in this,
Then,
this bill.
then it will be a different question.
My lord, just a general, I don't want to mention any kind of a judgment, just a general submission or observation may be recorded by the honorable court that though a third member has passed a judgment, the matter be remanded back to the division bench. Division bench should consider the judgment and also apply the latest law applicable.
No. Division bench will not do anything else. Division bench has already given their judgment. It has to pass one final order only that A has already, technical member is the A.
Yes, sir.
He has given his judgment. B is the judicial member who has given his judgment.
Yes.
C is the member to whom it was referred to. He has given his judgment. Now a final order is to pass that on the basis of majority of these three, what would be the judgment? That formality is remaining. It will not be remanded that you reconsider your judgment and give a fresh judgment.
I'm not even wanting
No,
that, my lord.
no, but
I'm-
that your
my
judgment
lord, my lord, I'm just wanting one small thing that applicability of the latest law is a general principle. My lord, I just want to mention that terminal charges, Honorable Guwahati High Court, just 4 months before has passed, 4 to 5 months before has passed a judgment. I'm not stating, my lord, I'm just stating that latest law be considered in regard to terminal charges. No particular judgment, no
but-
particular section, my lord.
But now they will not, they cannot write a fresh judgment. None of them can write a fresh judgment. Once they have passed their judgment, they have to pass an order only in view of the judgment cited by you, final order. So in view of the submissions made by both of you, I am dismissing the appeal, remanding the matter to the tribunal to do the needful in person to the judgment cited by him. I will mention what is to be done. I'll write the orders in chamber, detailed orders in chamber.
My lord, the word dismiss may not be used, disposed to be used, since the matter is being remanded back to the tribunal.
Okay. Finish.
Much obliged, my lord.
ভিতৰত দিব, chamber dictation. None has appeared for the appellant on call. Let this matter be listed after puja vacation on a date to be fixed by the registrar.